All right, we're now on YouTube, muted. All right, let me go ahead and swear you in, Bradford. Raham, from the information you give, any testimony provide in the matter of the state versus William X. Frazier is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, thank you.
What's your name? How you call it?
Uh-oh. You stopped for 1 brief second.
Is anybody else having trouble hearing her?
Yes.
Yes.
Okay, we hear you now.
Mm-hmm.
Okay. Okay, go ahead, ADA Freeman.
Tell us your name and how you're employed.
Kyle Bradford, Clayton County Sheriff's Office.
And how long have you been working with the Clayton County Sheriff's Office?
About a year.
And is it Deputy or Sergeant Bradford?
Sergeant Bradford.
Sergeant Bradford. Okay. Sergeant, were you working with the Clayton County Sheriff's Office on June 2nd of 2020?
Yes, ma'am.
And on that particular day, let's see, this says 15:30 hours. What is that in regular time?
3:30.
3:30. And that's that 3:30 p.m.?
Yes, ma'am.
Okay. On that particular day, were you working with the Cobra unit patrolling the area of Thurman Road and Conley Road?
Yes, ma'am.
Okay. On that particular day, was there a Deputy Washington who was also out there?
Yes, ma'am.
Were you working as his supervisor at that time?
I was.
Okay. And were you made aware of contact or that Deputy Washington had with a white Honda Accord for a defective center brake light?
Yes, ma'am.
Okay. Now, when Deputy Washington made that stop, were you also there?
Not at the time of the stop, no, ma'am.
Okay. When did you arrive there?
Upon the subject being, he tried to flee from the stop and he got tased.
Okay. And when you say the subject tried to flee, would that be Mr. Tillery or Mr. Frazier?
That would be Mr. Tillery.
Okay. And did you have contact with Mr. Frazier from the incident?
Briefly, just when I arrived. Yes, ma'am.
Okay. When you arrived on the scene, where was Mr. Frazier?
Give me just a second. I'm going to refer back to this if you don't mind. Okay, so both of them would have been in the car by the time I got there.
Okay.
Yes,
And from your review of the report, did Mr. Frazier also flee?
he did. Mr. Tillery.
Judge, I'm going to object to personal knowledge because this individual, Sergeant Bradford, doesn't appear that he was present until after a certain set of events occurred, and I just don't know that this witness has personal knowledge to give this testimony.
Response?
Well, Your Honor, the fleeing, I don't believe Mr. Let me double check before I answer. I don't believe Mr. Frazier was charged with the fleeing. I was just trying to get to the I guess, where the narcotics were located, and I believe that Sergeant Bradford was there. And so I can certainly move on, Judge.
I'll just put a pin in this, that certainly an officer can reply, respond, rely on a representation of another officer when they make their report. So personal knowledge is not absolutely required. If Sergeant Bradford spoke to or looked at the report and indicated there was something that another officer made in his report, then he can rely on what the other officer made in his report. So I just want to put the pin in that for your objection, Counselor.
Thank you, Judge. Sergeant Bradford, just so we can be clear with the testimony, tell us what was going on when you arrived on the scene.
By the time I arrived on scene, because initially when they put out over the radio that they had one running, I immediately started in that direction. By the time I got there, they had the Mr. Tillery in custody and Mr. Frazier in custody at that time. They were walking. When they walked Mr. Tillery back is when Mr. Frazier actually attempted to flee too. But they searched the vehicle once both of them were in custody. So I was on scene at that point, but I did not search the vehicle.
Okay. Can you tell us, based on your review of the report that was submitted from the search of the vehicle,
Yes.
what was located?
So both deputies stated to me and in the report that there was an odor of marijuana coming from the vehicle. In the back seat, there was a red bag on the back seat floorboard. Inside the bag was approximately 140 grams of a green leafy substance, which was identified as marijuana. There was a digital scale and also packaging materials known as like bags. There was also a firearm located in the center console. It was a Springfield Armory XD9. The weapon was checked over GCIC, but did not come back stolen at the time. And then when Deputy Myers was going after Mr. Frazier, he retrieved a bag from him. And in the bag was a suspected ecstasy, approximately 20 grams, and 4 pills that were later identified as acetaminophen with hydrocodone. Neither either Mr. Frazier or Tillery claimed possession or stated that any of the things found in the vehicle belonged to either one of them.
And just so we're clear, the suspected ecstasy and the 4 pills that were later identified as the acetaminophen with the hydrocodone, those were located in a bag taken from Mr. Frazier?
Yes, ma'am.
Were these items field tested?
Yes, ma'am.
And what were the results of the field test?
Let me just refresh my... the only thing that we would have field tested was the ecstasy. We don't field test marijuana. Right. But the field tested positive for methamphetamine.
And the marijuana that was found, were you able to observe the marijuana?
Yes, ma'am. Just from all the cases, I've made hundreds of cases, been to multiple controlled burns. I was able to identify it as marijuana.
And just so we're clear, where was the firearm found?
In the center console. And both subjects were checked criminal history, and both were convicted.
Okay. When you were on your way to the scene, and I know you touched on this because one of the charges regarding Mr. Frazier was and obstruction.
Yes, ma'am.
When you were there, you were able to hear from dispatch information regarding Mr. Frazier's status.
Yes, ma'am. Mr. Frazier was, he had active warrants at a Clayton County Sheriff's Office and the Forest Park Police Department at the time.
And when you were also there, did he remain on the scene at all times?
No, ma'am. He attempted to flee as well.
And which deputy apprehended Mr. Frazier?
Deputy Myers.
And was Deputy Myers also one of the deputies that you supervised?
Yes, ma'am.
You indicated that there was a scale and other materials found in the car. Is that correct, Sergeant?
Yes, ma'am. In the bag with the suspected marijuana, there was a digital scale and packaging material, things that are commonly used or found with large quantities of drugs for distribution, for packaging of narcotics.
Did all of this take place in Clayton County?
Yes, ma'am.
Sergeant Bradford, and I know you indicated Deputy Myers was also there. Based on the information that you reviewed in the report, was there anything else found on Mr. Frazier's person?
Your Honor, I'm going to object from Sergeant Bradford just reading directly from the report in response to the questions. If he doesn't know, that's fine. You can just say, I'm not sure. And then Ms. Freeman can ask him if looking at the report would refresh his recollection.
And we could go through an extra step if you want to, or we can just allow him to refresh his recollection. Was it response?
Outside of the
Hold on. There is an objection on the table.
Well, Judge, I don't believe that Sergeant Bradford was reading straight from the report. What I asked him is from his review of the report, was there anything that Deputy Myers found on Mr. Frazier's person?
Okay, so you say not that he's not reading the report, he's just reviewing the report.
I think exactly. I think what Attorney Cleaver says that he objected to Sergeant Bradford reading. And correct me if I'm wrong, reading exactly from the report. And what I asked him is that from his review of the report, that he recalled did Deputy Myers find anything on Mr. Frazier's person?
Attorney Cleaver, is there any? Do you want to?
I'll withdraw my objection, Your Honor.
All right, thank you.
just based off the knowledge that I had of when I arrived on scene and speaking with them and then reviewing the report, the ecstasy, the pills, he was being patted down. I know he had a small amount of marijuana. I think it was approximately 6 grams. And that was, I guess, prior to him fleeing the scene was when he was being patted down. And he located approximately 6 grams of marijuana.
Okay. And again, all of this did take place in Clayton County?
Yes, ma'am, it did.
Thank you, Sergeant. I believe that's all I have, Judge.
Okay, cross-examination, Attorney Cleaver.
Thank you, Your Honor.
Yes, sir.
Good morning, Sergeant Bradford.
Hey, good morning, sir.
So if I understand it correctly, you did not arrive on scene at all until after Mr. Frazier was already in custody.
Yes, sir.
And now that we understand when you arrived, I want to back up to the initial stop of the vehicle. This vehicle was stopped because of a defective brake light and alleged window tint violation. Is that right?
Yes, sir.
But again, you weren't there to observe the headlight or the brake light?
Not the brake light. I did watch them test the window, and the window tint was 18%, which is under the legal limit is 32% in the state of Georgia.
And that would have occurred after the fact, though, right? Not during the time of the stop.
Go get them.
I don't think that they put the window tint on after they were stopped, sir, but that's just going off what I was told by my deputy.
And then once the vehicle is stopped, you also were not present for that initial interaction between Deputy Washington or Deputy Myers and Mr. Tillery or Mr. Frazier.
No, sir.
So you weren't there when either Deputy Myers or Deputy Washington conducted an investigation as to who owned the vehicle?
No, sir.
So you don't know who owns the vehicle?
I don't. I just know who was in possession of it that day.
Do you know who was in the driver's seat?
If you allow me to refer back, because I've made a bunch of cases myself since then. That would be Mr. Tillery that day. Mr. Tillery was in the driver's seat.
And from your understanding and review of this case, was Mr. Tillery the owner of the vehicle?
I'm not sure, sir. I didn't run the tag myself, so I don't know for sure.
And you're relying on the police report in regards to this particular information?
As far as who owns the vehicle?
Correct.
I have no knowledge of it, and I don't believe it specifies in the police report who actually registered owner of the vehicle is.
Doesn't the report state that Mr. Tillery provided his driver's license to the either Deputy Myers or Deputy Washington?
He did provide his driver's license, yes, sir.
And then you testified that there was an odor of marijuana in the vehicle?
That is what Deputy Washington and Deputy Myers both stated to me while on scene and in his police report. Yes, sir.
So you never, your testimony nor from your memory, do you ever recall detecting an odor of marijuana? I
do remember seeing a large amount of marijuana that came out of the vehicle and smelling that while we were looking at it and taking pictures of it.
But again, you weren't there with Deputy Washington or Deputy Myers to detect that initial odor of marijuana, which led to the pat down of Mr. Frazier.
Was not.
And similarly, you weren't there to conduct the pat down or observe personally the pat down of Mr. Frazier.
No, sir.
You again personally did not observe Mr. Tillery flee the area.
Heard it on the radio, but I didn't see it with my own eyes.
You didn't personally observe Mr. Tillery be tased by Deputy Washington?
I did not.
You didn't personally observe Mr. Frazier leave the area?
No, but in regards to both of them, I did have to come and speak with him due to him being tased. I do know he was tased because he told me he was tased.
You didn't observe the marijuana or alleged marijuana being taken from Mr. Frazier's pocket?
No, sir.
So when you arrive, it's after everybody's already in handcuffs, or are they in handcuffs, or are they in the car, or both?
They're in handcuffs. Excuse me, they're in handcuffs.
Standing outside the vehicle?
No, they were inside a patrol car when I got there.
Together or separate patrol cars?
If I recall correctly, they were in separate patrol cars. It was in the gas station parking lot. I don't remember exactly.
Now, you say you had a very brief contact with Mr. Frazier. Is that right?
I mainly had to speak with Mr. Tillery in reference to the use of force for him being tased. I just spoke briefly with both of them. Yes, sir.
What was your conversation with Mr. Frazier?
To be honest with you, I don't remember. He wasn't tased, so as far as the use of force, it wasn't really needed to speak with him much. I mainly needed to speak with Mr. Tillery, who got tased, advise his injuries and stuff like that.
So basically, your whole role or your purpose of being present during this investigation is to speak with the individual who was tased.
Well, that's part of being their supervisor, but also to arrive on scene to see what they have and what's going on. Yes, sir.
And I think your direct testimony was that you were not present or you did not observe the search of the vehicle.
I didn't.
So again, you're relying on the statements of others to describe where things were found.
I'm relying on the deputies. Yes, sir.
So you didn't personally observe any of these items in any of their described locations.
I did not.
So based on your own personal observations, you don't know what items belong to who.
No, sir. Based off what I read, neither one of them claimed anything.
But based on what you saw when you were there personally, you don't know what items belong to who.
I don't. I know what my deputies told me.
I understand that. The firearm, was that checked to see if it was stolen?
Through GCIC, yes, sir.
And that result came back negative for stolen?
At the time it did. I haven't followed up. I know sometimes they're just not on GCIC, but as far as that day, it did not come back stolen on GCIC.
Was there any indication of who the firearm might be registered to?
That's something that has to take place afterwards. And like I said, I haven't followed up on that particular firearm to see who actually owns it.
So at this point in time, we don't know who the firearm is registered to?
No, sir.
What does it take to determine who a firearm is registered to?
Our evidence custodian conducts the ATF trace, and all that does, though, that traces it back to actually who purchased from whatever store. But then they have to reach out to them and ask, do they still currently own it? Did they sell it to somebody? If they did, who did they sell it to? So, I mean, it could be hit or miss. That's something I could follow up with, but I have not had a chance to follow up on.
Now, you're the supervising sergeant of these two deputies, correct?
Correct. Yes, sir.
Do you know why they searched the vehicle?
The odor of marijuana.
Just based on the odor alone?
That's probable cause in the state of Georgia.
Do you know if they had been arrested prior to the search?
I don't believe that would be the case, because that doesn't make sense or go with what the report says.
So you don't recall any statements that Mr. Frazier might have made to you?
Not to me. No, sir. Now, if he made a statement to someone else, I can't even tell you that, because I'm not sure either.
So even if he had discussed with Deputy Washington or Deputy Myers the circumstances of what had happened, you wouldn't know what was said?
I wouldn't. No, sir.
You don't know the circumstances of why either Mr. Tillery or Mr. Frazier ran on foot?
I know Mr. Frazier had active arrest warrants and also a bunch of drugs located on his person. And I know Mr. Tillery, there was a bunch of drugs pulled out of the car with a gun. So to me, that sounds like a pretty good reason to run.
You testified that there was a red bag with marijuana and packaging materials in a digital scale.
Yes, sir.
That was, your testimony is pursuant to the search that was located in the back seat floorboard.
Once they searched the car, that was located in the back seat floorboard. Yes, sir.
You don't know which side of the vehicle, passenger or driver side floorboard?
I don't want to. Give me just a second so I can tell you for sure. I'm going to just briefly look at it again. I couldn't tell you if it was the driver's side or passenger side. No, sir.
And for the center console, do you know at the time of the search of the center console whether the center console was open or closed?
I don't. No, sir.
So in regards to the firearm in the center console and the red bag in the back seat, you don't have any knowledge that Mr. Frazier would have known those materials were in the vehicle?
I couldn't tell you for sure. No, sir. I know that the bag that was covered off of his person when he fled on foot.
That's on his person, but the bag in the back seat, did the search reveal any identifying information about who the bag might have belonged to?
I believe so. No, sir.
And you never made any inquiries or between either suspect about who belonged to what or what belonged to who?
Outside of them, the deputies on scene speaking to them about that, that's not something I would come out on scene and do. I don't step into their particular cases, but based off what I read from the report, neither subject claimed possession of any of the items located.
So Mr. Frazier, according to the report, never admitted to possessing those items.
Correct.
No further questions, Your Honor.
Redirect.
Just 1 minute, Your Honor. Your Honor, I don't have any further questions.
Or any other witnesses for the state?
No, Your Honor.
Okay.
The state rests.
Any witnesses for the defense, Attorney Cleaver?
No, Your Honor.
Argument?
The state waives opening.
Your Honor, can you hear me?
Absolutely.
Okay. All right. So, Your Honor, when looking at this investigation, who is our best source of information? It's going to be Deputy Myers and Deputy Washington. They're the ones who observe a traffic violation. They're the ones who conduct the stop. They're the ones who have personal contact with Mr. Frazier and Mr. Tillery. They have there's an exchange of driver's licenses. They get them out. There's a detection of odor of marijuana. They get them out of the vehicle. And then, according to the testimony, Mr. Tillery flees on foot, and then Mr. Frazier later does. That would be great if we heard this, and then the search is conducted by these two deputies, but that'd be great if we heard the testimony from them. But unfortunately, that's not the source of information presented to Your Honor. We're getting this information to Your Honor secondhand through Sergeant Bradford, that he arrives way after the fact. He doesn't get there until, per his testimony, both individuals are in custody and an arrest decision has already been made. He has brief contact, in his words, with Mr. Frazier, but he can't remember what was said. He doesn't know what statements were made either by Mr. Frazier or by Mr. Tillery. He's relying entirely on secondhand information from these other two deputies. He doesn't know how the search was specifically conducted. He's stated specifically to Your Honor, he doesn't know what items belong to who. He could only surmise that the items found on Mr. Frazier, which was some marijuana in his pocket, and I think hydrocodone and ecstasy pills were in his backpack on his person. Your Honor heard testimony that the firearm was located in the center console. There's no inclination of who owns the firearm. We do know that Mr. Tillery's the driver of the vehicle. Presumably he owns the vehicle, but there's not even information presented to Your Honor by the state that, well, this, you know, the vehicle's registered to him, that the driver's license was checked out. But it seems to be that it's Mr. Tillery's vehicle. He's got a gun in his center console, which is closed, and he's got a bag in the back seat that's closed that Sergeant Bradford also testified that he's not sure who it belongs to. There's no follow-up investigation on the firearm. He doesn't know specifically in the back seat where this red bag with the marijuana scale and packaging materials are located. I don't know if he's the one who conducts the field test. It's just very attenuated, his testimony, Your Honor. And I don't believe there's sufficient evidence to support a probable cause determination for the marijuana that's found in the red bag, for the trafficking material or the scales or the packaging, which is supposed to support the state's possession with intent to distribute charge. There's no inclination that Mr. Frazier ever knew that those materials were in the vehicle. There's no indication of the circumstances of why Mr. Frazier was in the vehicle in the first place. We're just not getting good information from Sergeant Bradford. I understand these other witnesses might not be available, but they would be the best source of information for the court to make a good, for the court to be fully informed about whether there's probable cause or not. At most, Your Honor, I would say there's probable cause to support charges for the items that are found on Mr. Frazier's person. What the ecstasy and hydrocodone pills in his backpack and the marijuana found in his pocket, but not in relation to the firearm that's in the center console, not in relation to the marijuana, the felony amount of marijuana that's found in the red bag, nor the possession with intent to distribute based upon the packaging materials or the scale. I'm just looking over my notes here, Your Honor. Don't want to miss anything. And there's no conversation between Sergeant Bradford and Mr. Tillery that could give the court some additional information. It's just all based, and I know hearsay is admissible at these types of hearings, but it is hearsay information. I think that is part of the court's analysis in determining the credibility and weight that should be given to the evidence presented. So in our estimation, Your Honor, there's probable cause for the items that are found on his person, but I don't believe Mr. Frazier knew, and they have to prove knowingly possess. Just because they're in the car with him and he's a passenger doesn't mean he knew about those items. And even with a lower standard of probable cause, I still don't believe there's sufficient evidence. So I would ask Your Honor to dismiss those charges.
Right. Thank you, Counselor. A.D. Freeman.
Thank you, Your Honor. So first, I would like to say a lot of what Attorney Cleaver wants to argue is certainly for whether it's suppression motions or arguments to be made in Superior Court. And while I understand what he would like for the testimony to be, you know, at this stage, we believe that the testimony from Sergeant Bradford, who was a supervisor of Deputy Washington and Deputy Myers, was sufficient. I would like to say that one of the things Attorney Cleaver indicated, and it was misstating the testimony of Sergeant Bradford. He said that Sergeant Bradford stated that, or that he he said something to the effect of that he didn't recall if anybody made any statements to talk about their circumstances. What Sergeant Bradford testified to was that based on the report that no one claimed the items that were located. And he could certainly review that information from the report. And Mr. Frazier's not charged with anything regarding the stop, regarding the defective equipment or anything of that nature. Sergeant Bradford did testify to, he was aware that Mr. Frazier did try to flee, and that's when Deputy Myers located the items located on his person, which were the ecstasy and now the items that were located in the car, Your Honor, was that based on the testimony for Sergeant Bradford, which he based it on the information that he received from his two deputies, with the gun that was found in the center console, as well as the other items that were found in the bag. There was a digital scale, which certainly in the packaging materials would certainly go to the possession with intent to distribute. And then the gun, we heard Sergeant Bradford testify that Mr. Frazier did have active warrants, and so we were asking at this point that all the charges be bound over to Superior Court.
All right. So I have a problem with this case. First of all, that center console, was it open? Was it closed? If it's closed, you can't impute the ownership, the possession, even if Mr. Frazier had access to the center console. If it's open, then you got a better argument. If it's closed, he's not the driver. So, and I agree with Attorney Cleaver that Sergeant Bradford was not the best witness to bring for this particular hearing, because if I have questions, then you know I'm not going to find probable cause. So I'm going to tell you where we are. I do not find probable cause for the weapon, because there's no testimony, there's no information as to if that console was open or closed. Bradford never said, I don't know. And if I don't know, I'm not going to assume otherwise. So I don't find probable cause for the two weapons. Well, one weapon, two charges. So that's gone. And that's warrant number, that's the 1611-131, possession of firearm by a convicted felon, and possession of firearm during a crime, 1611-106. Those are both gone. I don't find probable cause for either one of those. The VGCSA, there's two VGCSA schedule. I guess those are for the, hold on, let me go back to the notes. All right, so there was ecstasy and hydrocodone. I find probable cause for 1613-30 twice. Those two warrants I find probable cause for. The possession of marijuana, I believe the marijuana was in a red bag, 5 ounces of marijuana in a red bag on the floorboard of the back seat. I do find probable cause for obstruction, possession of drug-related objects. Those, apparently there was a digital scale. I wouldn't have understood this until Attorney Cleaver brought it to my attention. There was a digital scale in the bag with the marijuana, and that red bag was in the rear of the vehicle, on the floorboard of the back seat. I'm going to find probable cause for the marijuana. Everything except for the two weapons is what I find probable cause for. And that's it.
Judge, maybe Sergeant Bradford be excused.
Yes.
Thank you, Sergeant.
Thank you, Your Honor.
I'll give my arm a sec. No problem.
Right. So I think that Attorney Reddick wants to talk to her client at the jail. Powell is your client?
Yes, Your Yes, Your Honor.
All right, let me bring you to breakout room 3. No, 2. I'm going to move you to breakout room 2. And then I'm going to move the jail to breakout room 2 as well. So Attorney Reddick can speak with her client, Mr. Powell. If you would bring him to the podium and let him speak to his attorney.
And I think Attorney Cleaver was still there, and Judge Attorney Cleaver and I had been going back and forth about a bond. And what I just text him if he wants to respond to my text before he leaves off, because I think Mr. Frazier, he's not on a bond calendar until the 4th.
You're right, Ms. Freeman. I think it's September 4th at 8 a.m. is when we're scheduled for a bond hearing date.
Mm-hmm.
Okay.
And so, given that the 2 weapons charges were dismissed, the amount that you were asking me for, I will consent to it if you want me to write it up.
Let me just absolutely confirm that with Mr. Frazier before, just in an abundance of caution, just to let him know what your most recent offer is. That way I can get his express permission, and then we can take care of it.
Okay, and the jail went away. Or is the jail in the breakout room, Judge?
They're in the breakout room.
Oh, okay. Okay.
Attorney Reddick is speaking with her client, Mr. Powell.
Okay. So, Casey, if you want to wait to see if you can get a breakout room.
Sure.
Okay.
Do you need to make a call to where are you supposed to be? What county did you say you're supposed to be?
Gwinnett County, Your Honor. They're in a Zoom. I think we're pretty far down the calendar. So, and I had emailed the solicitor handling the case that I was before Your Honor. So I don't think it'll be an issue if I sit for another couple minutes to let Mr. Frazier know.
All right.
And Your Honor, I have an updated announcement if that's possible.
All right. Absolutely.
After speaking with Mr. Beatles, he referred me to a family friend who indicated that they in fact had hired an attorney. I'm not sure if that attorney received notice. He was able to give me the last name of the attorney as well as the attorney's phone number.
Who is the attorney?
The last name is Herron, Herron, Herron.
Okay.
Does the court want the phone number also?
I don't. I'm not going to call. Ms. Moultrie, can you send a chat to Ms. Moultrie? Let me come off YouTube. All right, we are now on YouTube. All right, very good. So let's go ahead and start over. Officer Joseph, you have been sworn in. Attorney ADA Freeman, you were asking him about where he was employed and how long he was employed. Detective.
Yes, Detective, if you can repeat that. Tell us your name and where you were employed and how long you've been employed there.
Detective Henry Joseph, Clay County Police Department. I've been employed since May 23rd of 2016.
Detective, were you working with the Clayton County Police Department on July 25th of 2020?
Yes, ma'am.
And around that date, did you receive an assignment to investigate the case involving a victim, Frank Sotero Salvatore?
Yes, ma'am.
And did this involve our defendant, James Brown?
Yes.
How did you get involved in this investigation?
I was on call for that week, for that weekend, and basically I got called out by Sergeant Sawyer. We got called out to Southside Inn 6370 Old Dixie Road in reference to a vehicle, the victim's vehicle, crashing into the hotel, one of the hotel rooms. Then during the investigation, excuse me, my son. Taylor, go over there, please. I'm on the phone. Okay, well, go pee. Excuse me. I'm sorry. Okay, go ahead.
If you could, I think you were telling us, so was there a call regarding an accident?
Yes, there was the initial call was a vehicle crashing into one of the rooms out the south side end over there at 6370 Old Dixie Road. Upon arrival, officer made contact with the victim who was in the driver's seat of the vehicle. He stated that he had been shot. They observed a gunshot wound to the right side of the back of the victim.
Did you arrive on the scene?
Once uniform, upstairs. Excuse me. Go upstairs now.
Detective, you make sure.
I apologize.
No, we understand. Make sure you mute yourself when you have to do that. Yeah. So you were saying, did you go to the scene?
Yes. Once officers got the victim transported to the hospital, once they blocked off the area, they contacted Criminal Investigation Division, and that's when we responded out to the scene.
And just so we're clear, when you got to the scene, the victim had been transported for...
Yes, the victim had already been transported to AMC. When I got there, the vehicle was still, of course, was still inside the hotel room, crashed.
And just so we're clear, you said this was at the car went into a hotel room?
Yes, over at the south side end.
Okay. So when you got there, were you able to speak to any witnesses about what happened?
Oh, no, I spoke to the officers that were on scene, and they stated that during the investigation, they found skid marks from the hotel next door, the American Inn Suite, 6358 Old Dixie Road. They could see that the skids led to the south side in which he struck into the hotel room.
With that information, did you go to that hotel to try to speak to anyone to see what happened?
Well, once I arrived on scene, officers had already obtained written statements. They talked to witnesses. Not two of the witnesses, but the victim did hit two vehicles during the incident.
And what else did you learn from the statements that had been gathered from the scene?
Well, what we learned during the investigation was that we observed video. We looked at video surveillance during that time of the incident, and we observed the black Chevy Impala that the victim was inside, and we observed through the victim sitting inside the vehicle, and we observed three of the males outside of the vehicle, standing around the vehicle.
Where was the video surveillance from?
American Inn Suites, next door to the South Side Inn Suites, where the victim struck his vehicle into.
What were you able to gather from watching the video surveillance?
What we gathered from was what we see. The first initial watching the video, we see that the victim is in the black Chevy Impala. We see three males outside standing. We see the defendant, James Brown, enter the front passenger side of the vehicle, and we see the one of the other suspects standing outside, and then we see another suspect enter the rear side of the vehicle. Once that third suspect enter the rear side of the vehicle, you see the victim jump up. Once the victim, you can see him jump up, and you see him put the car in reverse and the car immediately reverses. One of these suspects is still standing there watching the vehicle reverse. When the vehicle reverses, you see the suspect walk off, and then you see the vehicle come, because the vehicle, when it reverses, it leaves the screen, and you just see one of the suspects. Then when the suspect leaves and walk off, you see the black Chevy Impala come back across, and you see the vehicle speeding ahead of the south side end, which it struck one of the hotels on the other side.
Could you tell when the car came back across, could you tell if the defendant, James Brown, and I think you said another occupant, were still in the vehicle?
No, you could not tell due to how fast the vehicle was crossing the screen when you watch it. But when the vehicle did reverse, James Brown and the other suspect, Demetrius Tarrant, was in the vehicle.
Okay.
The only person that was not in the vehicle was the other suspect.
Were you able to determine, I guess, what went on in the vehicle or before they got in the vehicle?
We could not tell what was going on between all parties. All we know that basically something occurred to where the victim reversed his vehicle and wind up, putting his vehicle forward and crashing into the hotel room. That was the first initial. We didn't know, but of course, gathering more information, we found out that it was a drug deal gone bad, a planned armed robbery.
And how were you able to determine that, Detective?
Well, this happened early Saturday morning. Monday, the 27th, one of our sheriff deputies. Well, let me back up. During the investigation on Saturday, we found that there was a white Toyota RAV4 that was leaving the scene. Okay, so that Toyota RAV4, basically, we put out a bolo for that vehicle. That all officers in the county look out for that vehicle because it is in relation to an incident that occurred with the victim. On Monday, one of our sheriff deputies seen that same RAV4 in the same property of where the incident happened at 6358 Old Dixie Road. Okay, that deputy made contact with one of the suspects, D'Angelo Millette. He was involved in another incident where it was another incident where he was detained. The deputies called us and told us that we might have somebody that was involved in the incident. So myself and another detective went out to that location, 6358 on the 27th, and made contact with D'Angelo Millette, the suspect. He came back to our headquarters. He spoke with us, read a Miranda, and he stated that there was a planned drug deal that basically went wrong. James Brown and Demetrius Tarrant was part of that drug deal that went bad.
Detective, this was information gathered from Mr. Millette.
Yes, Millette. Yes, during the interview, he basically stated what happened. It was a drug deal that gone bad, involving heroin. He stated that James Brown and Demetrius Tarrant planned to buy drugs or sell drugs to the victim.
Were you able to speak to the victim at all during this investigation?
No, the victim is not responding. The last time I went to the hospital at AMC, he's paralyzed from the waist down, and he's not even awake.
Were officers able to locate anything in the victim's vehicle regarding what was going on?
On that's the 25th of when the incident happened. No, but we did get a search warrant for the vehicle, which I executed that search warrant that Monday, the 27th, which I found clothes, money, and I did find what looked to be cocaine, or it could be some other drug substance wrapped up in a dollar bill.
Were you able to get a statement from the defendant, James Brown?
No, I interviewed him. It was audio recorded.
Did Mr. Brown make any admissions about this drug deal gone bad?
Yes, when we got the warrants for James Brown, because D'Angelo Millette stated that he identified James Brown as being on the scene, the one in the vehicle with Demetrius Tarrant. So when we got the warrants for him, and when the fugitive unit from the sheriff's department was able to go and get Mr. James Brown, of course, I spoke with him about the incident. He stated that on that day, on the 25th, he was working at the Texaco. Okay. A female that he knows around the neighborhood named, I think, Joyce, he stated, came to him and stated that the victim wanted to buy, I guess, heroin. Okay. So he met with that victim, and the victim told him that he wanted to buy some heroin, but he needed to get some money. James Brown stated that the victim went inside the Texaco over there on Terra Boulevard, Upper Riverdale Road, and I think he said he took out $40. Okay. James Brown stated that him and the victim drove to 6358 Old Dixie Road over there at the American Inn Suites. As the victim was waiting inside his vehicle, James Brown went around different rooms trying to find someone that had heroin so he could sell it to the victim. Okay. James Brown said he went to a couple people to try and try to find out who has heroin so they can sell it to the victim. James Brown stated that he met with D'Angelo Millette, who he called Hit. He identified D'Angelo Millette. He said that Hit didn't have any heroin, but he's gonna call Truth. He called him Truth, which he identified as Demetrius Tarrant. He basically said D'Angelo Millette called Demetrius Tarrant. Demetrius Tarrant came to the location, 6358 Old Dixie Road, and basically he told him that, hey, the victim wants to, buy some heroin. But I think he did say that they didn't have any heroin, but cocaine. It was cocaine. The initial thing was cocaine. He wanted some cocaine. But when Tarrant got on scene, they said that they didn't have any cocaine. But the James Brown said, okay, well, the victim says he has heroin that he's going to sell and that he has a gram. So he said they walked up to the vehicle. He walked up with D'Angelo Millette and Demetrius Tarrant inside to the vehicle. He got inside the passenger vehicle. I guess to do the drug deal. He stated that D'Angelo Millette and Demetrius Tarrant was there behind him. He stated that if I can remember that, he stated that he don't remember him getting in the vehicle, but he thinks he said that somebody did get in the back of the vehicle. He doesn't know if it was Hit or Tarrant. He said as he was sitting in the vehicle, he said some words was exchanged between the victim and Demetrius Tarrant, and basically a gun went off and the vehicle went in reverse. He said when the vehicle went in reverse, it crashed and hit two vehicles, and basically him and Demetrius Tarrant got out the vehicle and ran and left the location. James Brown left with the shooter, Demetrius Tarrant, left the location and drove to Econo Lodge on Upper Riverdale Road with Demetrius Tarrant, the shooter. He stated that. Go ahead.
You said they drove to Econo Lodge?
Yes. Well, the Demetrius Tarrant drove a brown Buick, which James Brown got inside the vehicle with him and left the scene and drove to Econo Lodge. James Brown said he seen the weapon that Demetrius Tarrant used to shoot the victim. while they were inside the hotel room at the Econo Lodge up Riverdale Road. James Brown stated that he's seeing sheriff deputies arrive on scene at 6358 Old Dixie Road due to the victim crashing into the hotel room. I said, well, why you didn't call the police? Why you didn't go back over there? He said he was scared. I said, and he had enough amount of time. He said that he wasn't involved. He didn't know they were going to rob him. But I said, you had enough amount of time to tell the police what happened. Mr. James Brown facilitated this drug deal. He planned this drug deal with Demetria Tarrant and D'Angelo Millette, which led to the victim being shot in the back, which the victim is now paralyzed from the waist down. I can't hear you.
Did all of this happen in Clayton County?
Yes.
At this point, Detective, have you all been able to arrest Mr. Tarrant?
No, we have not. The last time I checked, he was still on the run, I guess. And I asked James Brown, does he know where Mr. Tarrant might be? Demetria Tarrant. He said by now he should be in Detroit. So I'm still working on trying to find out where he is. But we do have James Brown, of course, in custody, and we have D'Angelo Millette in custody as well.
Judge, I believe that's all I have. Thank you.
Okay, cross-examination, Attorney D. Williams.
I have some questions leading up to the actual accident, okay? You said that Mr. Brown told you that he met Mr. Salvatore at the Texaco?
Yes, on Cherry Boulevard in Upper Riverdale, yes.
Okay. And did you go to that Texaco to verify his story?
No, I didn't know. I did not do that yet, no.
Okay. And were you guys able to find Joyce to verify that part or no?
I actually was looking for Joyce a week and a half ago, and I could not find her. I actually live in the area, and I think I know who he's talking about, but I have not been able to find her.
Okay. And was Mr. Salvatore a guest at the America's Inn and Suites?
Was he a guest? No, he was not.
Was Mr. Brown a guest at American Inn and Suites?
He said he lived in a shed on property. There's a shed back there somewhere on property. But he does live on property over there at 6358 Old Dixie Road.
Okay. And what about Mr. Mallet? Did he have a room there?
Mr. Mallet, no.
And did Mr. Tarrant have a room there?
No, Tarrant is at Econo Lodge.
Oh, okay. Do you know how many days Mr. Tarrant was at the Econo Lodge?
No, I do not.
Okay. And I know you said you watched the surveillance. So was anyone in Mr. Salvatore's vehicle when you drove into the parking lot of American Inns and Suites?
Well, when we see the vehicle on the video surveillance, I mean, talking about the initial incident with the vehicle reverse and everything, we just we just see him inside the vehicle at first, and then we see James Brown, Demetria Tarrant, and D'Angelo Millette walk up to the vehicle, and then you see James Brown enter the front passenger side of the vehicle.
Okay. So when he drives up initially into the hotel, you can't really see in the vehicle?
No, I didn't know.
No. Okay. And did you see Mr. Brown knocking on room doors at the hotel?
No. He stated that's what he was doing.
Oh, that's what you stated, but you didn't see that on surveillance?
No.
Okay. And So all three defendants got into the vehicle?
James Brown got into the vehicle, and Demetrius Tarrant got into the vehicle. D'Angelo Millette was standing outside the vehicle while they were doing the drug deal.
Okay, so he never got in.
D'Angelo Millette did not. He never got in. He would open the back door, look in, but that's it.
Oh, okay. So the surveillance that you viewed, how far before the accident did you view the video?
Say that again.
For the video the surveillance that you viewed, how far in advance after the accident, before, like when the accident happened, did you watch it like 20 minutes in advance before the accident happened?
No, we just watched when the initial incident, because some of the cameras at the hotel did not catch everything. So we basically that was a good shot that we had, and we focused on that shot because that's the important shot where the incident happened, where he was shot, where the vehicle reversed, and when the vehicle drove past and went into that hotel room.
And did the surveillance have sound?
No.
And did you get a copy of the surveillance footage?
Did I get a copy of the surveillance? Yes, we did. Our CSI obtained that surveillance footage.
And is that part of the file you will provide to the DA's office?
I'm still working on the file. The case is not closed yet. We haven't got Demetrius Tarrant yet. So the case is, we're still gathering more evidence.
Okay. Have you turned over that? Never mind. Okay, so we're going to talk about the actual accident, okay?
Yes.
I just want to make sure I have all the defendants in the proper location. So you have Mr. Brown in the front passenger seat?
Yes, in the front passenger seat, yes.
And Mr. Tarrant was in the back, right behind Mr. Salvatore, or behind Mr. Brown?
Behind James Brown.
Behind James Brown. Okay. And I saw on the warrant that Mr. Mallett got hit by a car door. So which was the door open?
Demetrius Tarrant's door was open. His door was open because when Demetrius Tarrant went inside the rear passenger vehicle, when he opened that door, it's like he instantly pulled out the weapon, because you could see once he opened the door and once he gets in, the victim jumps up. So he instantly pulls out that weapon, and that the door is still open. So when matter of fact, I take that back. James Brown's door was open as well. When he reversed the vehicle, James Brown, the side of the vehicle he was on, that door hit D'Angelo Millette and spun him around.
Okay, so Mr. Brown's door is open, Mr. Tarrant's door is open, and when the vehicle backed up, both doors are open.
Mm-hmm.
Okay. And Mr. Mallett was standing next to the rear passenger door.
Mr. D'Angelo Millette was standing. He was standing like in between it.
Okay. And were the Impala windows tinted?
No, it was not.
And Mr. Salvatore has his back against the window because of because of the commotion. Right,
if you're looking at me right now, when Demetrius Tarrant enters the vehicle, you could see the victim go like this, and that's why he got shot on the right side of the back. In the back, he got shot on the right side because he does this, and then when he reverses, he's still at that position because he sees the gun.
Oh, I see. Okay. So on the surveillance, you're actually able to see Mr. Tarrant shoot Mr. Salvatore.
And you look at you cannot see him, the gun, but you can see the victim's movements. You could see him jump up.
Okay. Oh, so you can't actually see the gun shoot him?
No, you can't see that. You just see his maneuvers to the victim.
Okay. And the two vehicles he hit the the white RAV4?
No. He hit two other vehicles.
Do you know the type of vehicles they were?
The type of vehicles I'll have to refer to I'll refer to my notes. Give me a second. He hit a Dodge Caravan and a Ford Fusion.
Okay. And was anyone injured when the victim went in reverse?
As far as all parties involved in the incident or other bystanders?
Bystanders.
No.
No. Okay. And when he put the car, Mr. Salvador put the car in
Well, I
drive?
take that back. I take that back. When the vehicle reversed, no. But when the vehicle went forward and hit and went inside that hotel room, yes. I think the lady she suffered minor injuries, but she wasn't transported.
Okay. And that was Route 119 that the vehicle hit, correct?
Yes.
And were you able to get a statement from the young lady?
Oh, I'll have to look at the case file.
Do you know the victim's name?
You talking about the victim of the shooting?
No, the one who got that was in the room 119.
No, I'll refer to my notes. Give me a second. No, we don't. Not at this time. No, not at this time.
Okay. Do you know which EMT treated her at the scene?
Plain County EMS. You want the end? It was engine 1.
Now I want to talk about what happened immediately after the accident.
Mm-hmm.
Which officers were on scene?
What officer was on scene? We had the first initial officers. We had Officer M. Anderson, Sergeant McDaniel, Lieutenant Thrift, Officer Branham. Yeah, that's who I seen when I arrived on scene.
Okay.
But M. Anderson, Officer Anderson is the reporting officer, and Sergeant McDaniel was also on scene as well.
And do any of them have dash cam?
Body cam, yes.
Okay. And you said that Mr. Brown and Mr. Tarrant ran. Which direction did they run into?
We don't know. All we know that when that vehicle reversed, of course they got out the vehicle, because when it went back and crashed, they went inside the vehicle. So we don't know that area where he reversed. There's only one way to run, and that's towards Old Dixie, because that way is blocked off. So they have to run towards the Old Dixie Road. There's no other way to run to, or towards the hotel in between the halls. That's the only way they could run to, because you don't see them. You don't see them on camera. So if they're back in the vehicle, they're going to run to the nearest getaway area, which is I guess like the far right side edge of the hotel.
Okay, but you weren't able to see them running on surveillance, just the actual accident.
Mm-hmm.
Okay. So you don't even know where Mr. Mallet walked to after he got hit by the door.
No, he just walked off. And he said he walked off and he went to, yeah.
Okay. Do you know which EMT responded to Mr. Salvatore's injuries?
Talking about the it was engine one. I mean, engine one.
Oh, so the same one. Okay. Okay.
Yes. Should be.
AMC, what's AMC?
Atlanta Medical Center.
Oh, okay. Okay. So Mr. Salvatore wasn't able to speak to officers that night?
Not about in detail, as far as in detail of the incident. When the officer arrived on scene, when he was in the vehicle, he just stated he had got shot. He got shot.
Okay.
Mm-hmm.
So that was just on this. So when was the last time somebody spoke to Mr. Salvatore or tried to talk to Mr. Salvatore at the hospital?
I try to speak with him. He cannot speak. He's not even awake.
And when's the last time you went to the hospital?
This was about two weeks ago.
Okay.
I don't. Matter of fact, I have my notes of when I went. Give me a second. Okay, August 4th. I was there August 4th at 1700 hours. I was at Atlanta Medical Center in an attempt to talk to Mr. Salvatore, but like I said, he was not able to talk because, of course, he's not awake.
Is the hospital listing him as critical condition?
He's stable now. When I talked to the nurse, he's stable.
Okay.
But he does have a feeding tube and a ventilator.
Okay. So when the officers are trying to talk to him, that's all on body cam, correct?
Yes, that should be on body cam. Yes, we have body cam, so that body cam, should be on there.
And that's part of the file that you're going to provide to the DA's office?
Body cam is on Avail, so you guys will be able to obtain it.
Okay.
It's on our Avail web, which is our body cam, where all the body cam video footage is placed on.
Okay. And what items were stolen from Mr. Salvatore?
We don't know what items were stolen. We just during the execution of the search warrant. There's money around, there's drugs in the vehicle, but we don't know exactly what was taken. But of course, there was an intent to rob Mr. Salvatore, the victim.
Okay. Was there surveillance at the Southside Inn? That's the one where the car ran into the hotel room.
I do believe I haven't seen any video as of yet. This initial case was several detectives involved in this investigation. Of course, I'm the lead detective, but I only have the video of the actual incident where we could see. But we have that. We have not obtained any video of him actually crashing inside of that room.
And there were witnesses at the Southside Inn?
Yes, there was. We had one witness that stated they heard the gunshot, but we believe that was from the American Best Inn suite 6358.
And so that's the only witness you guys spoke to, one?
She just said she heard it. She didn't see it. She just heard it.
Okay. And pictures were taken at the scene?
Yes, pictures were taken at the scene, yes.
And what were the pictures of?
Pictures of the vehicle, pictures of the two vehicles that were hit by the victim's vehicle and all the scene.
Okay. And were any informants used during the course of this investigation?
Any who?
Informants?
Oh, no.
And all the defendants were identified by Mr. Mallett?
D'Angelo Mallett, yes, he stated who everyone was. I showed him pictures. He stated that was James Robert Brown. I showed him the other picture that was Demetrius Tarrant. And I also showed him other pictures as well. Well, we have other pictures as well of Demetrius Tehran at the Connell Lodge, which matched the same description of when he was on scene during the incident.
Okay. And you say you spoke with Mr. Brown. He was brought to the precinct when you spoke with him?
No, when the fugitives unit went ahead and placed Mr. Brown in custody, which he was at the same incident location, 6358 Old Dixie Road, they took him to jail. I didn't speak to him until like a week later.
A week later. And you have your whole interaction, the whole interaction was recorded?
Yeah, it was audio recorded, yes, at the jail.
And did he also write a statement? Did he also write a statement? Sorry.
No, he did not write a statement.
Okay. And the recording was entered into evidence?
Say again now?
The recording was entered into evidence?
It will be entered into evidence. I just have to transfer it from the computer to a DVD.
Okay. And you were the only one who questioned Mr. Brown?
No, I had me and Detective Marshland he was interviewing with me as well.
And was Mr. Brown Mirandized?
Yes, he was.
Did he have to sign a waiver?
Yes, he signed a Miranda statement for him.
Okay.
Signed and dated.
Okay. And the three parties, the three defendants, they knew each other prior to this incident?
Yes. They'll see each other around.
They saw each other around?
Yeah, they'll see each other around, but not like close friends, but they will just see each other around. Like James Brown stated in the interview, everybody knows him.
Okay, so they're just like acquaintances?
Yes.
Okay. I have no further questions for this witness.
Redirect?
No additional witnesses, Judge.
All right. Well, do you want to redirect this witness is what I was asking.
No, Your Honor.
Okay. All right. All right. So it sounds like the state is resting. The state has no witnesses. Do you have any witnesses, Attorney D. Williams?
No, Your Honor.
Okay. Argument?
The state waives opening, Judge.
So I just have closing. This state has not met their low burden of probable cause for armed robbery. The relevant part of the statute reads, a person commits the offense of armed robbery when he takes property of another. The state will argue he was at the scene of the robbery. However, that is not enough for even probable cause. The statute reads, a person may only be charged as a party to a crime if he directly commits the crime or he intentionally causes some other person to commit the crime. In such circumstances, the other person is not guilty. And in this case, we know Mr. Tarrant was the one who shot the weapon or allegedly shot the weapon. Another part of the statute is he intentionally evades or abets in the commission, or he intentionally advises, encourages, hires, or procures another. And in this case, the officer didn't present testimony that my client aided the robbery or encouraged the robbery, perhaps a drug deal, but not a robbery. We know who had the gun and who was likely the shooter, but it wasn't Mr. Brown. Even the officer testified that the wound was in the back of Mr. Salvatore. Yes, he did run away after witnessing something traumatic, but that was a reaction to being scared. Fight or flight, and my client decided to choose flight. It was a chaotic scene, and based on the testimony and the statute, I would ask for the court not to find probable cause for armed robbery.
Thank you. Okay. Attorney Freeman?
Thank you, Your Honor. We're asking that the charge, this one charge, be bound over. We heard from Detective that based on the video surveillance and the footage, they were able to determine what was going on. It is our attention that Mr. Brown helped to plan the robbery of Mr. Salvatore, that he did actively participate in this drug deal and the plan to rob Mr. Salvatore of the heroin. Certainly, there may be some other charges to come later, given when the victim is able to be interviewed as well as medical records. But we're asking that based on this detective's testimony of his observations from the video surveillance, talking with Mr. Mellette, one of the co-defendants, as well as Mr. Brown's statement himself, that this one count be bound over to Superior Court.
Okay. There's a lot of information, a lot of testimony to sift through. I'm just trying to.
It was, Your Honor.
I do find probable cause for this charge. I'm looking at the testimony of D'Angelo Mellette, who ID'd Mr. Brown as being in the vehicle in the front seat. There's some inconsistencies with what your client said to the detective in terms of what he was trying to do, his role in this. And I do find, today I find probable cause for the armed robbery. Frankly, I was trying to see if there was probable cause for more than that, but for now there is probable cause for the armed robbery. Okay?
Thank you, Your Honor. And this is one that's on the bond calendar Friday.
Thank you, Your Honor.
Am I still on YouTube?
Yes, Your Honor.
All right, thank you. All right, good morning, ladies and gentlemen. This is the Clayton County Magistrate Court, Superior Court bond hearing. I am Judge Richard Brown, sitting by designation as Superior Court Judge for the purpose of determining Superior Court bonds on felony cases. Representing the state is Assistant District Attorney Cheryl Freeman. And the calendar has already been called. The first case that we will hear will be the state of Georgia versus Manuel Marquez Martinez. He is represented by Attorney William Matos. And to assist will be certified Spanish interpreter, Ms. Deja Bermudez. At this time, I will administer the interpreter's oath. Solemnly swear firm you'll faithfully translate Spanish to English, English to Spanish, the proceedings before the court in an accurate manner to the best of your skill and knowledge.
I do.
Thank you. It should be noted that due to the coronavirus, this case is being handled through Zoom video conference as well as live on YouTube. The cases against Mr. Martinez. On the calendar, there are a total of 3 cases, and we will hear 2 of them. Ms. Bermudez, you need to go.
Yes, sir. Solamente para que conste en el acta, este caso se está llevando vía Zoom. En el caso del señor Martínez tenemos 3 cargos, pero solamente vamos a proceder en 2 cargos.
The 3 charges, the first one is statutory rape warrant number 2020 CW 53799.
En estos tres cargos, el primero es de estupro y la orden de arresto es 2020 CW 53799.
And Attorney William Matos, on behalf of Mr. Martinez, has advised the court as well as the district attorney that they are waiving that particular charge or case straight up to the trial court without a hearing this morning.
Y el abogado William Matos, de acuerdo con la fiscal, le ha notificado a la fiscal y al juez que él va a renunciar a la audiencia preliminar por este cargo y que lo está enviando directamente a los tribunales de litigios.
The two remaining cases that will be heard today, the first one is harassing phone calls, warrant number 2020 WA 11160.
Y los dos cargos que restan en este caso, uno de ellos es el 2020 CW 11160 y ese es por acoso a través de llamadas telefónicas.
The second charge is computer pornography, warrant number 2020 WA 11161.
Y el segundo cargo es pornografía por ordenador o por computadora y la orden de arresto es 2020 CW 11161.
All parties have announced ready to proceed.
Las partes han anunciado que están listas para proceder.
And I forgot to mention that today's calendar is heard by me, Judge Richard Brown. I did say that, sitting by designation, and the date is August 21st, 2020.
Y se me olvidó decir que la lista de causa está siendo escuchada por mí, el juez Richard Brown, sentado por designación como juez del Tribunal Superior, y que la fecha es 21 de agosto del 2020.
And representing the state is the attorney, Assistant District Attorney Cheryl Freeman.
Y que representando al Estado está el asistente de la Fiscalía, Cheryl Freeman.
Attorney Matos, this is your case. You may proceed.
Your Honor, I just want to, and I think me and Ms. Freeman have discussed that when we do the bond hearing today, it will be for all three warrants, so that we don't have to come back and redo and reinvent the wheel. So we just wanted to make, I guess he needs to understand that, so that it's just not simply waiving the preliminary hearing, but that we will consider bond on all his cases, so he understands, I guess, and his family understands.
Mr. Matos, the interpreter couldn't hear you well. Can you please repeat what you just said?
Just that me and Ms. Freeman have discussed this before, that when we do the bond hearing this morning, it'll be for all three charges, so that we're not coming back and redoing another bond hearing.
Que la señorita Freeman y yo hemos discutido en la mañana de hoy que la audiencia que vamos a tener es para los tres cargos, para no tener que regresar a tener una audiencia solamente por el otro cargo.
For the bond hearing.
Para la fianza, para pedir fianza.
Thank you, Ms. Bermudez. Okay. All right, Your Honor, real quickly, Mr. Manuel is 32 years of age. He's been in Forest Park about 8 years. He lives there.
Su señoría, el señor.
I'll slow down, Ms. Bermudez.
And Mr. Matos, I don't know if it's the volume, but the interpreter is having trouble being able to hear you.
All righty. You hear me now?
Yes, sir. Thank you. Just to make sure that that's what you said. You said that Mr. Marquez is 32 years of age and he's been in Forest Park for the last 8 years, correct?
That's the first part. Go ahead, yes.
Thank you. El señor Marquez tiene 32 años de edad y él ha vivido en Forest Park por 8 años.
He has several relatives in Forest Park.
Él tiene varios familiares en Forest Park.
Which include 3 brothers and 2 sisters.
lo cual incluye 3 hermanos y 2 hermanas.
As far as his criminal history,
Y cuando tiene que ver con antecedentes penales,
I believe all he has is a no license.
yo creo que todo lo que él tiene es un cargo por no licencia.
He works at a stone and stucco company.
Él trabaja en una compañía de stones y estuco.
Okay, it's called escapes.com.
Se llama escapes.com.
And he's been there around 4 years.
Y él ha estado ahí por 4 años.
Okay. I don't think Mr. Manuel is a risk of flight.
Yo no creo que él es un riesgo de darse a la fuga.
His family is in a position to post a bond.
Sus familiares están en una posición de pagar fianza.
Okay. And as it, obviously as it relates to these charges, there were 2 initial charges and then there was a 3rd charge added.
Y obviamente cuando tiene que ver con estos cargos, inicialmente eran 2 cargos y luego se le añadió un cargo.
Okay. I'm assuming the 2nd charge was based on a forensic interview.
Y yo asumo que el segundo cargo estuvo basado en una entrevista forense.
Okay. Which obviously we have at this stage of the legal proceedings we wouldn't have access to.
Lo cual en esta etapa del procedimiento legal nosotros no tenemos acceso a ella.
So basically we'd ask the court to set a reasonable bond.
Básicamente le estamos pidiendo al juez que le conceda una fianza razonable.
I'm aware that the 90-day rule may not apply.
Yo tengo conocimiento que la regla de los 90 días puede ser que no aplique o no califique.
But at the same time, I don't, assuming that we're looking at probably 2021 when we get to his court date.
Can you repeat that, Mr. Matos?
But assuming that we will not get to his court date until 2021.
Porque yo estoy asumiendo que él no va a poder tener una corte hasta el 2021.
I don't think the court order would allow just definitely indefinite detention.
Y yo no creo que el juez va a permitir que esto solamente no se le dé una atención o no se le preste atención de manera indefinida.
That's to go. We understand that the bond may be high.
Yo entiendo que quizás la fianza podría ser alta.
And it's going to require various conditions.
Y que se le va a requerir varias condiciones.
But we'd ask the court based on his criminal history.
Can you repeat that for the interpreter, Mr. Mato?
I will, but based on his criminal history.
Pero basado en sus antecedentes penales.
And again, the delays that we will have in appearing in court.
Y también el retraso que tendríamos para poder comparecer ante los tribunales.
We'd ask the court again to set a reasonable bond with conditions, Your Honor.
Una vez más, le pedimos al juez que le conceda una fianza razonable con sus condiciones.
I hear from the state.
Thank you, Your Honor.
Voy a escuchar por parte del Estado. Gracias, Su Señoría.
Mr. Martinez does not have a bond on the statutory rape nor the computer pornography and child exploitation charges.
El señor Martínez no tiene fianza en el cargo de estupro y de pornografía por ordenador y por explotación infantil.
Regarding the computer pornography charge and the harassing phone calls, Judge,
Con relación al cargo de pornografía por ordenador y acoso a través de llamadas telefónicas, Su Señoría.
the defendant admitted to law enforcement
El acusado le admitió a los agentes de la Fuerza del Orden Público
about having the photos and making the phone call to the 15-year-old victim?
De que él tenía las fotografías y que le había hecho las llamadas a la víctima de 15 años.
The defendant actually stated he was angry at the victim for not coming to see him.
El acusado dio declaraciones de que él estaba enojado con la víctima porque ella no lo había ido a ver.
He admitted that to who?
The police officer, this was with the, let me see which law enforcement agency.
Y él se lo,
I'm sorry, Deja.
it's okay. Y él se lo admitió a quién, a los agentes de policía, y esto fue con el departamento de policía de Forest Park.
This is with the Forest Park Police Department, Judge.
Thank you.
Esto fue el departamento de policía de Forest Park, su señoría. Gracias.
He actually admitted to have at least 4 pictures of a provocative nature of this victim.
Él admitió haber tenido por lo menos 4 fotografías de naturaleza provocante de esta víctima.
Judge, I'm not sure if the alleged victim of the child pornography or the computer pornography is the same as the stat rape. I don't have that warrant in front of me.
Su señoría, yo no sé si la víctima en el caso de pornografía por ordenador es la misma víctima del cargo de estupro, porque yo no tengo la orden de arresto enfrente mío.
That certainly is a recent charge. In looking at the computer, it says confined date August 18th.
Y esto es un cargo reciente, y mirando a la computadora dice que esto se arrestó, se ejecutó el 21 de agosto. Can you repeat the date, Ms. Freeman?
August 18th.
18 de agosto. Thank you.
Well, given the information that we have, Judge,
Y dada la información que nosotros tenemos, su señoría,
the state is asking that Mr. Martinez
el Estado está pidiendo que el señor Martínez
remain on no bond status for the 2 felony charges.
permanezca sin fianza por los 2 cargos por delito grave.
Thank you, Your Honor.
Muchas gracias, su señoría.
All right, the court has a couple of questions. Attorney Matos.
El juez tiene un par de preguntas para el abogado Matos.
Do you have any documentation to confirm this employment?
¿Usted tiene alguna documentación que confirme que él está empleado?
I can provide that to you. I don't have it with me now, but I can provide it to you. I got
Yo-
that straight from his brother, Your Honor.
Yo no lo tengo conmigo, pero yo se lo puedo hacer llegar, su señoría.
Next question.
Próxima pregunta.
Do you show where he was living and who he was living with?
Yes, he was
Muestra dónde él vivía y con quién vivía.
Yes, he was living with his 3 brothers and 2 sisters. It's actually the address that's listed on the warrant, Your Honor.
Sí, su señoría, él vivía con sus 3 hermanos y sus 2 hermanas en la dirección que está nombrada en la orden de arresto, o registrada en la orden de arresto.
Are any of them present on this Zoom this morning?
No, Your Honor, they're not, Your Honor.
¿Hay algunos de ellos que estén presentes vía Zoom en la mañana de hoy? No, su señoría. No.
Next question.
La próxima pregunta.
Is he a U.S. citizen?
He's not, Your Honor. There's I believe, an immigration hold on him with Clayton County, Your Honor.
No, él no lo es, su señoría. Yo creo que él tiene una orden de detención de migración en el condado de Clayton.
Attorney Matos, do you know if the alleged victim of the statutory rape is the same alleged victim as the child exploitation?
I believe it is, Your Honor. If you read the police report did the initial interview, and then in the report they mentioned that they're going to take her to do a forensic interview. 99.9% sure that it's the same victim, Your Honor.
Señor Matos, ¿cree usted que la víctima del caso de estupro es la misma víctima del caso de explotación infantil? Yo creo que sí lo es, su señoría, porque se nombra a la víctima en la orden de arresto y ellos dicen que la van a llevar a una entrevista forense. Yo creo que 99% que sí lo es.
Those are all the questions I have. Is there anything else you'd like to say, Attorney Matos?
Again, Your Honor, we'd ask the court to set a reasonable bond. I understand the emergency order, but unless can't have it both ways. We can't have an emergency order and no grand juries and no trials. This isn't Guantanamo Bay. We'd ask the court to set a reasonable bond, and obviously we'll go from there. But to hold someone indefinite when there is no idea when we're going to have either a grand jury or trial, I don't think that is the basis of a no bond condition. No bond is, you've got grand juries running, you can indict cases pretty quickly. In this situation, we're not even close to that, Your Honor.
Do you know how long your client's been in jail?
Since the date of arrest, since the same day that's on the warrant, Your Honor. He was arrested that same day.
I think that's June 28th this year.
Correct. That's correct.
So it will be 90 days and how long, June?
August 28th.
Okay.
Or June, July, June 20, July, or September 28th.
September 28th.
I'm sorry, September 28th.
All right, Attorney Freeman, anything else you wish to say?
Your Honor, just that we're asking that he remain on a no bond status given the charges.
Abogada Freeman, ¿algo que usted quiera decir? Solamente que él permanezca sin tener fianza basado en los cargos.
All right, considering what's been presented by both the defense and the state, the court is going to deny bond for the following reason.
Considerando todo lo que ha sido presentado por parte de la defensa y por parte del Estado, el juez va a denegar la fianza por las siguientes razones.
First, regarding significant ties to the community, although it's been stated that he has a job that he's been working for a number of years, there's no documentation to confirm that.
Primero, por los vínculos o los lazos con la comunidad, aunque se ha dicho de que él tiene empleo, pero no ha habido documentación que apoye esto.
Next, there's not a clear, confirmed information regarding the living with 3 brothers and 2 sisters. The court would need to get more information regarding that living situation, which is not available this morning.
Segundo, la información no está clara o confirmada de que él vive con 3 hermanos y 2 hermanas. El juez tendría que recibir información con relación a cuál es su situación con lo de su vivienda.
Next, given the fact that he's not a United States citizen, the court has concern about him being a flight risk or potentially failing to return back to court.
Y dado el hecho de que él no es ciudadano americano, al juez le inquieta de que él podría darse a la fuga y que él no podría comparecer ante el tribunal.
Regarding Attorney Matos' concern about being held indefinitely.
Y con relación a la preocupación del abogado Matos de que a él lo podrían detener de manera indefinida.
That is the purpose for the requirement under law that that the person be indicted within 90 days. And so that we have another month at least before that time frame,
Okay.
which would address that concern.
Y ese es el propósito de la ley, de que la persona tiene que ser acusada formalmente antes de los 90 días y a nosotros todavía no queda más o menos un mes antes de que podamos lidiar con esa inquietud.
And then we have an additional charge of statutory rape for which there's needs to be confirmation regarding whether it is the same or different alleged victim.
Y luego tenemos el cargo de estupro, donde también necesitamos tener información que nos confirme si la presunta víctima es la misma.
However, that is additional, that additional charge is another consideration that the court cannot overlook regarding its decision on bond.
Y ese cargo adicional es algo que el juez no puede no tomar en consideración en el momento de otorgarle una fianza.
Given the court has no reason to necessarily doubt that Mr. Martinez is employed and is living with brothers and sisters. It just needs confirmation.
El juez no tiene ninguna razón para dudar de que el señor Martínez está empleado y de que vive con sus hermanos y sus hermanas. Solamente necesita confirmación de esto.
And the court is not overlooking the fact that it appears that he cooperated with law enforcement.
Y el juez no está dejando de tomar en cuenta de que él cooperó con los agentes de la Fuerza del Orden Público.
So with that additional information, the court could reconsider its position, and if not within the next, before the next 90 days, it can definitely would have to set a bond after 90 days.
Okay, thank you, Your Honor.
Y tomando esta información adicional, el juez podría reconsiderar el concederle fianza, aunque le tienen que conceder fianza antes de los 90 días.
Anything else, Attorney Matos?
No, that's it. Thank you, Your Honor.
Attorney Freeman?
¿Algo más, abogado Matos, abogada Freeman?
All right, so that will conclude the hearing on the Martinez case. All parties associated with this case, and if you have nothing else, you can be excused. And I'll ask the jail to Mr. Martinez, you can go back with the deputy.
Sure, I'll email you that waiver like within a few seconds, okay?
All right, thank you.
And Ms. Bermudez, you can be excused. Thank you for your, well, let's make sure we don't need you for anything else.
Yes, sir.
Attorney Freeman, or any other attorney?
I don't think we need Ms. Deja for any other cases.
All right. Okay. Thank you, Ms. Bermudez. Have a good weekend.
Thank you, everyone. Have a good weekend.
Have a good one.
Bye.
All right. That'll conclude this case. So now let's go to, I think, Anthony Smith is what I heard Attorney Freeman say. We'll start that one in about 2 or 3 minutes. When we get the paperwork ready, so stand by.
Judge, you want Smith Anthony?
Please.
Okay.
Your Honor, is it possible for Matthew Hunt to go next because the witness has to get back to work?
There's no objection. If the jail can hear us, if you can bring up Matthew Hunt
I got you.
instead of Anthony Smith. Thank you.
Got you, Ms. Freeman.
Thank you.
Okay, we're ready for Anthony Smith.
Judge, they switched
If
it.
they switched, if we could do Matthew Hunt, Mr. Williams, her witness has to get back to work. And I said I had no objection to doing Hunt instead of Smith, since the witness is already on the call.
Okay, so I have to go now and pull that paperwork. Hold 1 minute.
Oh, we apologize, Judge.
No problem. We're ready for Matthew Hunt. All right, court is calling the case State of Georgia versus Matthew Jeffrey Hunt. 1 second. State's represented by Assistant District Attorney Cheryl Freeman, and Mr. Hunt's represented by Assistant Public Defender Angela D. Williams. All parties have announced ready to proceed. Mr. Hunt has 5 charges. Aggravated assault by strangulation, warrant number 2020 CW 52863. Cruel to the children in the 3rd degree, 52864. False imprisonment, 52865. Aggravated assault with a deadly weapon, 52866. And battered family violence, 52867. Attorney D. Williams, you may proceed.
Thank you, Your Honor. So my client, Mr. Hunt, has been in jail for 52 days, and he could afford a total bond of $38,500, which would be it's already written out $8,500 for the aggravated assault, $5,000 for the cruelty to children. He doesn't have a bond on the false imprisonment, so I'm asking for $5,000 for false imprisonment and $15,000 for the other aggravated assault charge, and to keep the battery charge at $5,000, which he already has. Mr. Hunt has worked at the T&K Discount Meats in Riverdale for the
All right,
past
hold on, I'm sorry. Can you repeat that and go a little bit slower?
Oh, the numbers?
No, you just said about he worked somewhere. Is that what you just said?
Yes, he works at T&K Discount Meats, which is in Riverdale.
All right, go ahead.
He's been there for 10 years. His cousin is the owner of that store, and he has kept him gainfully employed. Mr. Hunt has 3 kids with the victim in this case, Ms. Turner. His kids are 3, 2, and 6 months. If Mr. Hunt is granted a bond, he would live with his aunt, who I'm going to call as a witness. She works for the Department of Labor and is willing to let Mr. Hunt live in her home as long as he follows the family plan that they have in place for him. And if the court allows it, he has close family throughout the metro Atlanta area. His mother lives in Covington. His
Can you
father
go just a little bit slower?
I'm sorry.
Okay, so follow the family plan to live with the aunt. And then what did you say after that?
His mother, if the court will allow the family plan to happen, I'm going to lay it out for you when I call the aunt as a witness.
Okay.
His mother lives in Covington, Georgia. His father lives in Atlanta. He would have no problems getting to court either by Uber or one of his family members. He also has a 17-year-old son and an 11-year-old son by other women, but they do live in Atlanta. His father is a commercial plumber in Atlanta, and his mother works for the state of Georgia. She goes into homes doing inspections, and she reports her findings to the court. He does have a bit of a criminal history, and I believe just 1 felony conviction. I'm sure the state will correct me if I'm wrong about that. His felony was for marijuana possession in 2015. He does have an open aggravated assault and battery case with the same victim. However, when that went to a preliminary hearing, that case was dismissed and it was brought back by a true bill. The victim contacted me and informed me that she exaggerated to the police a bit about this case. And she wants contact with Mr. Hunt, and she has no fear or concerns about him getting a bond. I believe the victim spoke with the victim's advocate office, and I'll let the state relate any concerns the victim may have that I'm not aware of.
Oh, I'm sorry to interrupt. When was the open aggravated assault and battery case?
It's current. There is open in Clayton County. There is a case number from October of 2019, case number 2019 CR 02704. Charges are aggravated assault and a battery.
All right, thank you. You may continue, Attorney DeWee.
Thank you. I spoke with Mr. Kirk Walker, which is Mr. Hunt's uncle, and Mr. Walker has a job ready for Mr. Hunt, and he will learn a trade of commercial plumbing under the tutelage of his uncle as a commercial plumber. That's the same profession as his father. His uncle let me know that he could use help with his business because he has a lot of work and he has contracts that will take him well until the middle of 2021. Coronavirus did not impact his business and he is busy. And I would like to call my client's aunt, Angel Rollins, to the stand as a witness.
All right.
Ms. Rollins, would you please raise your right hand? Do you promise to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
You may put your hand down. Would you please state your name for the court?
Angel Rollins.
And how are you acquainted with Mr. Hunt?
I'm his aunt.
And what do you do for a living?
I work for the Georgia Department of Labor.
And what is your job title?
I'm a business services recruiter. I service 6 counties in the state of Georgia. I work primarily with employers. And at this moment, due to COVID-19, I'm in the house actually working with aliens, fraud, and trying to get our Georgians paid.
Okay. And would Mr. Hunt be allowed to stay with you if he was to get a bond today?
Yes, he would.
And would you please tell the court the plan that the family has come up with for Mr. Hunt if he was to get a bond?
Well, the plan that we would like to petition the court for is for him to be able to bond out and come to my residence and potentially leave to go to North Carolina to start employment. My brother has several opportunities for him on different job sites down the coast. And I have spoken with my brother, and he has agreed to be in full communication and liable for Matthew with Clayton County courts.
Okay. And so if he was to have a court date, would he be able to stay with you in Georgia?
Absolutely.
Okay. And how would he get from North Carolina to Georgia to get to your home?
My brother would transport him, or either I would provide transportation to get him there.
Okay. And when Mr. Hunt is in Georgia, would Ms. Turner be allowed to come to your home?
Absolutely not.
Okay. And is the family in general okay with Ms. Turner being around Mr. Hunt?
No, we are not. We fear for his safety.
Can you identify who Ms. Turner is, Attorney D. Williams?
That's the victim in this case?
It hadn't been mentioned, so I just want to make sure that we're clear on that for the record. Okay, so the victim, the alleged victim's name is what? Say it again, please.
Ms. Turner, I believe Aquisha Turner?
All right, you may continue.
And how much money would Mr. Hunt be earning if he was to work for your brother, Mr. Walker?
On a weekly basis, between $800 and $1,500 a week.
Okay. I have no further questions for this witness.
Attorney Freeman, any questions?
No, Your Honor.
All right. Ms. Rollins, thank you for joining and thank you for your service.
Yes, sir.
And I have no other witnesses, just...
Hold a minute. Sorry. I have some questions. Ms. Rollins, Mr. Hunt is your nephew by what, sister or brother?
By my brother.
Is this the brother in North Carolina?
No, that's our baby brother. His father is Marvin Hunt.
Okay. All right. Do you know where Mr. Hunt was living prior to this alleged incident?
He was living with the alleged victim.
Do you know the alleged victim?
I do not know the alleged victim personally. I have had to come into family court. I met her on one occasion, but she is not welcome in our home or around our family.
From what I heard from the Attorney D. Williams, Mr. Hunt has 5 children.
Yes, sir.
All right, those are all the questions I have. Any other questions, Attorney D. Williams, Attorney Freeman, based on the court's question?
No, Your Honor.
No, Your Honor.
All right, anything else, Attorney D. Williams?
Just closing.
Okay, go ahead.
Okay. I would ask the court to grant Mr. Hunt a bond total of $38,500. The family has an airtight plan for Mr. Hunt to be productive while he is waiting to go to trial. He wants to fight these charges and clear his name. We asked the court for permission for Mr. Hunt to be with his uncle when he is not in Georgia working. When he is in Georgia, he will stay with his aunt. He will be sure to get to court. The only way she will allow him to stay with her is if he works for his uncle or if he is working. He has to be gainfully employed if he is to live under her roof. He will be learning a family trade, earning extra income, and he will be around positive male influences if he's allowed to go work with his uncle. He is not a flight risk because North Carolina is extremely closed. And like I already stated, when he has court, he's going to be with his aunt to ensure he's ready for any court dates and he doesn't miss any court dates. He knows that he has to keep an updated address on file with his attorney and the court. And in order to learn his trade, he will have to have essentially no physical contact with Ms. Turner. So witness intimidation is not an issue because he will be in North Carolina unless he has court. And if he is in Georgia, he's going to stay with his aunt, who will not allow him to have her at the house. And he can't be around her around their residence. When I spoke with his uncle, he told me that his schedule is from 5 a.m. to 8 to 9 p.m. and he'll be working the entire time. So when he is done with work, his uncle told me that he'll only have time to probably take a shower and go to sleep because he has to wake back up to be ready to work at 5 a.m. I know the state's going to ask for no bond, but I asked the court to please consider the plan that his family has come up with for Mr. Hunt to guarantee his success and to move forward with his life and not to waste his time being idle in jail waiting for a bond, because a high bond is essentially no bond. So once again, I just asked the court to consider the family plan and allow him to learn the trade of the family business and to earn money so he can take care of his children. And if he needs a curfew when he's in Georgia, we can do a curfew to ensure he's at the home and not, of course, being idle. And that's all I have.
All right, before Attorney Freeman, something I forgot to inquire about, and that is, I understand that he has an open case that was initially, I think, dismissed and then picked back up by the state.
Well, I don't have that information, Judge. That's what Mr. Williams stated, but I don't have that. But it has been indicted.
All right. So my question is, if it's been indicted, was Mr. Hunt, but did he get out of jail and get rearrested?
No, Your Honor.
He did not. Okay. So
Judge,
then,
I don't know. I don't know that.
All right. So let me just say this. I cannot make a decision about granting bond until or unless I get the additional information on the other case to include whether he had a bond condition to have no contact with the alleged victim. And there should have been a bond order. So the determining the status of that previous case is going to be a necessity to make any further determinations. So if we need to go to another case while we try to recover that information, either through the DA's office or through the court, we're going to need that. So we might need to come back to it.
Well, Judge, I will say, because I don't want to represent that that's information I can get right now, but I will say this, according to CPUA, the indictment was filed on October 9th of 2019. The case came into our office in July of 2019. So I don't know after if Mr. Hunt had a true bill bench warrant on that case or what happened, but the current charges occurred on June 22nd of this year. If the court wanted to go into recess, I don't know how much information I can find to try to see if I can locate the case that's in our office. I don't, just because half of the attorneys in our office are not here, half are here, and it's just trying to figure out where that file may be. But it was indicted on October 9th of 2019.
Indicted on October 2019, and you said this second set of charges occurred in June of 2020?
Yes, Your Honor.
Okay. All right. Then.
And in court case inquiry states that it was dismissed by Judge West.
Okay. Well, was it dismissed not the indictment, not after it was indicted.
Right, it was not. Exactly. So whether or not it was dismissed by Judge West at this point, it was indicted. And at this point, we don't even know if it was dismissed based on a hearing or a witness, but he was indicted on those charges.
All right. Okay. So, so I'm going to go ahead and make a decision on the case. Anybody else have anything?
Do you want me to go over the history other than the open case, Your Honor?
Please.
Or, okay. And just for the record, the state is asking that he stay on no bond status. These were serious charges. And one of the things in the case which stands out is where the victim indicated to the officers that Mr. Hunt made her get on her knees and apologize to him and indicated that he wanted her to refer to him as God. And the officer noted that he did observe discoloration and bruising to her knees from her having to get on her knees. But just going through the history of Mr. Hunt, because he does have some probation violations. So let me start at the beginning. So from, 2006, there was an obstruction. 2007, misdemeanor possession of marijuana. There was a probation violation on that possession of marijuana. 2008, there's another obstruction and a probation violation. When we get to 2015, there is a possession with intent of marijuana, which of course is a felony that was here in Clayton County. In 2011, we have a harassing phone calls. In 2011, we also have a probation violation or a probation revocation in 2011. We have another probation violation in 2014. In 2015, there's a criminal trespass and with 2 counts of criminal trespass. 2015, there's a probation violation. In 2016, there is a hit and run, as well as a driving with a suspended license. There is a probation revocation in 2017. And then we have the current charges. And I'll also state that in the police report, they stated that that Mr. Hunt had an outstanding warrant for the city of Forest Park.
That was regarding the case we were talking about that was indicted.
Okay. So given his history, and his history does show that he has probation violations, probation revocations, and I certainly heard what Mr. Hunt's aunt said about the plan the family has in place. But given his history and the charges, the state believes that there is a substantial likelihood that he will reoffend. He's shown by the numerous probation violations and revocations that that there's certainly a propensity to not following what he's been instructed to do. So the state is asking that for the charges where he does not have a bond, that he remain on no bond status. If the court is inclined to grant a bond, we are asking on the false imprisonment.
The court's not going to.
Okay. Thank you, Your Honor.
All right. The court will adopt the state's position as to no bond, that the Mr. Hunt has shown a continued and repeated disregard for probation, and he also has 2 obstruction convictions, which shows either a concern for flight or failing to appear. In addition to that, he has a pending charge of the same or similar nature, potentially against the same victim or another victim, but the nature of the charges are the same. So the court finds he poses significant risk of committing felonies pending trial. He has a good family in his corner. He has resources and all these great things that he could choose to take advantage of, but it appears up to this point, he may be taking people's kindness for weakness. And at this point, the court will deny the bond for all the reasons stated. That'll conclude this case. Mr. Hunt can go back with the deputy. And then Ms. Rollins, I'm sorry, we're not able to grant a bond, but thank you for making yourself available. And unless Attorney D. Williams have anything else on this case, we're going to prepare to go to the next case.
No, Your Honor. Thank you. Thank you, Ms. Rawlings.
Thank you.
All right. Okay, so the next one I have is, we have said Anthony Smith.
Anthony Smith, yes, Judge.
Okay.
The judge. Come on.
Stand by.
Mr. Smith, I did speak with her. Okay.
Okay, we are about to go on the record with next case. The state of Georgia versus Anthony Jerome Smith. Mr. Smith has 2 charges: aggravated assault and warrant numbers 2020 WA09360, Cruel to the Children 09361. Cheryl Freeman representing the state. We have Attorney Camille Reddick with the Public Defender's Office representing Mr. Smith. All parties have to proceed. Attorney Reddick, you may proceed.
Morning, Your Honor. I want to draw the court's attention to, in particular, the one count that Mr. Smith does not have a bond on. It would be the aggravated assault. He currently does have a bond on the cruelty to children of $4,000. Your Honor, Mr. Smith and I are hoping that you grant him a bond on that one count not to exceed $5,000. The biggest basis for our request is that Mr. Smith has been in custody 84 days. And as the court is well aware, at the 90th day, he would be entitled to a bond if he is not indicted. The court is also aware that we are still under a judicial emergency and that grand jurors will not be brought in prior to September, which would take Mr. Smith well beyond his 90th day, since we are already at 84 days. So that is the biggest reason we are asking, Your Honor, to set a bond, because he's going to be entitled to one, and the court knows that it won't get indicted prior to his entitlement day. We are not able to kind of get him on the calendar right at the 90th day, but I believe that because we're only 6 days away, the court could make the determination that he would not be indicted timely, and thus he should be guaranteed a bond on that one count. In addition, Your Honor, looking at the Ayala factors, I myself, as well as I believe the DA's office, has spoken with the victim, Ms. Pamela Greason. She indicated that she is not concerned or does not have any safety concerns with regard to Mr. Smith. So that means that he is not a danger to harass, intimidate, or otherwise harm witnesses in this case. The main witness will be Ms. Greason, and she has no concerns for her safety or that of her children. I asked her when I spoke with her whether or not she needed him to stay completely away. She indicated that she has no concerns with him communicating with her because they do share a child. Although they are no longer in a relationship, she made that abundantly clear, and I need Mr. Smith to hear me say that. She said, y'all not in a relationship anymore, Mr. Smith. She does not have concerns with communicating with you regarding your child that you share with her. And so, Your Honor, she has no safety concerns. He is not a flight risk. He has been a resident of the metropolitan Georgia area since 1997. He has worked. His job is still waiting for him at the mechanic shop where he was at when he was arrested on this case. So he would have a job to go back to earn an income. He's not a flight risk. He does have a history. Let's not hide that from the court. We're going to be forthright. He does have a history. And in fact, he is on a probation for a criminal damage charge that involves this same young lady. But again, she has no concerns for her safety. So we would ask the court to set a reasonable bond of no more than $10,000 on the aggravated assault. He is not a flight risk. He is not at risk to reoffend or commit offenses while out on bond. He is not a threat to harass or otherwise intimidate witnesses because she has no fear of because the main victim has no fear of Mr. Smith.
Attorney Reddick, let me ask you this. Do you have any documentation regarding him being gainfully employed?
Miss Greason has all his paperwork, and I could get it from her, but I did speak with her and she's available by phone. She told me last night that if anybody had to ask. Well, the answer is in my hand. No, I do not have it. I can get provided to the court today if it's something that's required.
Right, I get it. Now, the next question, do you have any information about where he was living or will be living?
He was living with Miss Greason. He will be living with his sister, a family member. We can provide that address to the court. I just don't want to do it on YouTube, Judge.
Okay, so is that sister available this morning?
I didn't ask her if she was going to be available this morning. I did not, but I can find out and let the court know.
Well, no, we're in the hearing now. So now let's see. All right, then those are the few questions I had before I allow Attorney Freeman to proceed. Go ahead, Attorney Freeman.
Thank you, Your Honor. Just a little bit about the case before I get into his history. This defendant poured gasoline on the victim. When the police got there, the victim smelled of gasoline, as well as there was gasoline smell in the residence. There was a 17-year-old who was there, who was not the child of the defendant, who had indicated that she woke up to her mom screaming and yelling. And she said that she saw.
Your Honor, at this point, I'm going to object. I believe the standard for a bond would be the Ayala factors, not necessarily the facts of the case, but whether or not he meets or does not meet, in the court's opinion, the Ayala factors as outlined by the courts.
Well, Judge, I believe, given the serious nature of this, of the allegations, as well as what the one witness says, certainly goes to the possibility of flight, as well as intimidating the witness. The victim, the 17-year-old I was speaking of, is not a child of the defendant, but she was a witness there who indicated she saw the defendant pouring the gasoline and holding a black lighter in his hand.
Then, Your Honor, I believe would be appropriate would be testimony of that young lady saying whether or not she does, in fact, have a fear or safety concern, as we had to find out from Ms. Greason, who is the main witness, who's the alleged victim in the case. But to go into the facts or what the state believes the facts are of the case to try to use that is not appropriate. As the court is aware, the Supreme Court of Georgia, in a case of murder, has indicated that those facts on his face were not sufficient to overcome whether or not the client met the Ayala factors to warrant a bond.
Attorney Freeman, what's your response to Attorney Reddick citing the case and the proposition of what it stands?
Your Honor, again, I stand on my argument is that, and that's not all the information I was going to provide. So it's not just standing on the facts alone, but that's an example of the possibility for witness intimidation. The witness indicated to the police that was the scariest moment for her.
Attorney Freeman, I'm sorry to interrupt.
Okay.
But I'm understanding Attorney Reddick to say that under the law, you're not allowed to go into this type of information. And she cited made reference to a case. I'm asking you, do you share that understanding? Are you aware of that case, or do you disagree with that?
Well, Your Honor, my understanding of the interpretation of that case is I'm not standing on the facts of this alone, and I'm not giving the entire facts. What I was merely submitted to the court is that there certainly is a potential for witness intimidation. And I don't believe that I have to have her, that witness testify in today's hearing, but given that she indicated to the police that was the scariest moment of her life.
In Your Honor, I will bring the court's attention to what the court's history has been. When we have cases where the victim has been reached out to.
Which court's history?
Well, magistrate courts I've dealt with in Clayton County. Okay. Judge Dallas and Judge West have relied on when the state says we spoke to the victim and the victim has safety concerns. They've relied on that. In this case, we've spoken to the victim. She does not have safety concerns. Now the state is trying to not allow that to stand as it has allowed it to stand when it works in their favor. And that's my concern, that when it works in their favor, when they reach out to the victims and the victims say, we have safety concerns, that's sufficient. But today, when both sides have reached out to the victim and she does not have safety concerns, that's not being allowed to stand. Now we're going back to something that was said to law enforcement almost 90 days ago. And I acknowledge the victim told me herself when she was in the moment, she felt that way. But today, currently, she does not feel that way. So I'm not understanding why it's good when it works in their favor. But the fact that it's not working in their favor today is not sufficient to show that he is not a danger to harass, intimidate, or otherwise threaten witnesses.
And Judge, I didn't say anything about Pamela Greason. I was speaking of the other victim who is Ms. Greason's daughter.
But that's a victim you haven't spoken to. Because I reached out.
Hold on, Attorney Reddick. She didn't interrupt you. Go ahead, Attorney Reddick.
And so certainly Pamela Greason has indicated that she does not have safety concerns. She has indicated that. But again, Your Honor, that I have not even completed my argument. So I have not gone back on anything regarding Pamela Greason.
Okay, so let me rule on the objection. I overruled the objection. Number one, as far as what Judge West or Judge Dallas may have done or the reason they have done it, the court is going to stand on its own decision based on its case-by-case basis. And number two is the court is allowed to consider the facts and circumstances surrounding this particular case, each case as it relates to issues of bond, to even form a framework from which to put in context anything else. And number three, the argument that the alleged victim has no safety concerns. We still have minor children as well, and the court has to consider their interests and welfare and safety as well. So I overrule the objection. Attorney Freeman, you may proceed.
Thank you, Your Honor. And just going into the history of Mr. Smith, because based on the history, I do believe that there is a substantial likelihood that he'll reoffend. Starting in 1997, there was an entering auto where he received probation. That was in Brunswick. Going to another case in 1997, there was a burglary that was in Glenn County. Going again to 1997, it says in Brunswick, that may still be Glenn County, but there was a VGCSA, it doesn't state what type of drug it was, where he received 7 years confinement. He was paroled in 2000 for that one. In 2002, there was a public indecency that was in Clayton County. In 2004, theft by receiving stolen property, a possession of marijuana less than an ounce, and that theft by receiving was a felony. That was in Clayton County, where he did get 5 years confinement. In 2006, there was given a false name. There was a parole violation in 2006. There was another parole violation in 2008. In 2014, there was a possession of a firearm by a convicted felon. That was in Clayton County. He got 5 years probation. In 2019, there was a conviction for 3 counts of criminal damaging in the second degree. That's in Clayton County, where he received 5 years probation. And that was out of Judge Powers' courtroom. And then we have the current charges. And so Mr. Smith is currently on probation. And he was on probation when these charges occurred. So we believe that given that there is a substantial likelihood that he will reoffend. I'm not sure if a BOP has been filed, but the state is asking on the aggravated assault that he remain on no bond status. And that's all I have.
Okay, stand by 1 second.
I'm going to take him to make sure that.
All right, sorry about that. So anything else, Attorney Reddick?
Yes, Your Honor. The other witness, the alleged 17-year-old in the case, resides with Ms. Greason. And again, I had conversations with Ms. Greason last night, and she indicated that she nor the other witness, her 17-year-old daughter who came downstairs, have safety concerns. So I don't believe that that is a factor. But the better part and the stronger part of our argument, Your Honor. I apologize, Judge. I'm having a bit technical difficulty.
No problem.
I did post in the chat, Your Honor, the information where Mr. Smith works. We literally were calling and verifying while Ms. Freeman was making her argument. It is JD Auto Repair. We spoke with the manager. Her name is Rebecca, and we put the phone number in there. So Your Honor could have that information regarding employment. But again, I believe the better part of our argument, the stronger part of our argument, is that the statute that for the 90 days does not matter. It does not consider any of the Ayala factors. It's a blanket statute that says if the case is not indicted within 90 days, he is entitled to a bond. I believe that the court in its discretion could use that statute at this time to provide my client with a bond, as he has been in 84 days. He will reach his 90th day in 6 days. The court is well aware that our Supreme Court Chief Judge has just extended our judicial emergency into September which means Mr. Smith would not have an opportunity to even be indicted prior to hitting his 90th day. So that is our better argument. We understand that he has a significant history. I believe that my client is now a different person. But of course, Your Honor could find that that difference came about because of the 84 days in custody. He does not have current VOP hold out of Judge Powers. And he is not, I don't believe that my client would be a flight risk. Every time he's gotten in trouble, he's stayed in the jurisdiction. He's never had an FTA, never absconded, never had to be hunted down by any jurisdiction that he's had a case in. He's always submitted himself to the jurisdiction of the court. So, Your Honor, considering the statute and the Ayala factors, we are asking that Your Honor set a reasonable bond of no more than $10,000 on the aggravated assault.
Do you think he's a different person after 84 days and he did 7 years on burglary?
Yes, Your Honor. You know, we don't know when changes occur in people.
Oh, you're right.
And they're defining moments in everyone's life. So.
I got you. Okay. Attorney Freeman, what you got? You're on mute.
Your Honor, again, I stand on everything that I presented to the court. And I do realize that the 90-day mark is coming up and he will be entitled to a bond. If the court is so inclined to grant a bond on the aggravated assault, this is one of those cases, Judge, where, like I said, the allegations that he poured gasoline onto our victim, I don't think the victim has denied that at all, even when she spoke to Ms. Reddick. And
she has not. She hasn't acknowledged that. Right.
And it is one of those cases where, this is not a victim who is saying it didn't happen or does not want to go forward. And so if the court is inclined to grant a bond because the closeness of the 90th day, we will certainly ask for a really high bond on this ag assault, given that he is currently on probation and his other history. We would ask for, a minimum of $75,000 at least, and a GPS, as well as a stay away. And I know the victim is asking for contact, so it will be a no violent contact. I guess my concern is for someone to pour gasoline on someone. I still, I have concerns about that, even though the victim is asking for a no violent contact. Just because, especially if there's an allegation that he did have a lighter in his hand. I mean, I have concerns about the contact. And again, that's if the court is inclined to grant a bond.
Right. Considering everything, I think for judicial economy, the court is inclined to grant a bond, but given this prior history and the nature of the fact and circumstances surrounding this case, given the fact that he's presently on probation, and given the fact that the court has concerns, as we know, oftentimes alleged victims lack certain things to protect themselves, let alone their minor children. So the court will set a bond in the amount of $75,000. It really doesn't have much discretion to go against the state's recommendation for all the reasons indicated, and the court would not allow contact, especially without hearing directly from the alleged victim. But that would be the order of the court. $75,000 on the aggravated assault. There's already $4,000 on the other charge, and no contact.
I'll give that to you, Your Honor. Give me like 2 minutes or 5 minutes.
So the total bond amount, Your Honor, is $79,000.
Correct.
Thank you, Judge.
All right, unless there's anything else, then Mr. Smith can go back with the deputy. That'll conclude this case. We'll prepare the orders and we'll get them signed and sent out.
Right, and Judge, given that this is an order from the court, would you like for me to send it to the public defender's office so they can sign off on it, or just send it directly to you?
Yeah, let's get them to sign off too.
Okay, if I could have 5 minutes.
Okay, yes. Court recess for 5 minutes.
All right, thank you.
Thank you. The next case will be Thompson, Devon Thompson.
Judge Brown, you need Thompson?
Yes, sir.
Yeah, a little bit.
Yes.
Your Honor, before you begin the next hearing, may the Public Defender's Office excuse me, have no more matters pending before the.
Yes, ma'am. Thank you very much. Have a great weekend.
Thank you, Judge.
They bringing it up now?
Please mute your phone. We're standing by for Attorney Freeman.
Judge, I'm not sure whose iPhone that is that's on.
Miss Thompson, can you hear me?
Yes, I can.
Okay, do you see a little mute button on there? Can you hit the mute button?
Yes, sir.
Okay.
All right. So we're ready to go forward on the next case. Court is calling the case State of Georgia versus Devon L. Thompson, represented by Defense Attorney Kenneth Muhammad. State's represented by Assistant District Attorney Cheryl Freeman. Mr. Thompson has 11 charges. They are listed in chronological order, starting with the case of 2020 CW 50438 39 40 41 42 43 44 45 46 47 and 48. Corresponding charges are driving with no tag or expired tag, serious injury by vehicle, failure to make, and it's got cut off something, failure to make something. And that's on 40. On 41, reckless driving. 42, improper lane change. 43, fleeing from police. 44, obstruction, firefighter. 45, hit and run accident. 46, strike and fix object. And 47 is cut off, and 48 is cut off. So they will be announced as we proceed. So all parties have been announced ready to proceed. Attorney Muhammad, you may.
Thank you. Thank you, Judge. Excuse me. Judge, this case involves an attempt by Clayton County police officers to negotiate a traffic stop. And near the end of that attempt, the officer performed a pit maneuver on the vehicle that my client was driving. The vehicle, as a result of a pit maneuver, spun, hit an object, and the passenger of the car, who was my client's fiance, passed away. It's alleged that before the pit maneuver was performed, the various incidents that are charged happened. I have my client's mother on the phone. If he is granted a bond, he would live with her. I don't know how much time she has. So would the court allow me to question her at the start and then go into the rest of my presentation?
Any objection from the state?
No objection.
You may.
Okay, Ms. Thompson, are you able to make it where we are able to see you, or is that possible?
Yes, sir.
Okay.
Can you see me?
I can. Okay.
Yes.
Can you raise your right hand? Okay. Do you swear or affirm that the testimony that you will give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Okay, you can put your hand down. And can you state your full name for the record?
Angelique LaShawn Thompson.
Okay, and what is your relationship to Devon Thompson?
That's my second born son.
Okay, if he is granted a bond, would he live at the residence that you are living in?
Yes, sir.
Okay, and what do you do for a living?
I'm a certified chef.
You said certified chef?
Yes, I cook.
Okay, and who all lives at the residence?
My daughter Erica and my son Jacob.
Okay, Judge, I have no further questions. Oh, and what city is that? Don't say the full address, but what city is the residence in?
Stone Mountain.
Okay, no further questions, Judge.
Any questions, Attorney Freeman?
I guess, I'm sorry, ma'am. First, my name is Cheryl Freeman. I'm with the Clayton County District Attorney's Office. Tell me your last name again.
Thompson.
Ms. Thompson, okay. And your current address is in Clayton County, you stated?
It's Stone Mountain.
It's Stone Mountain, okay.
It's in Stone Mountain, Gwinnett.
Okay. Before your son was incarcerated in Clayton County, where was he living? I think you froze.
All right, we'll stand by, see if we can get her back.
Okay.
Oh, okay. It looks like she's back.
Right, Ms. Thompson, you froze a little bit. Can
you see me?
Okay, yes, I can see you.
Okay.
Okay, are you on your way to work or somewhere?
Yes, ma'am.
Oh,
yes,
okay.
ma'am.
Okay, all right.
Clean.
Okay, before your son was arrested, where was he living?
He was living between me and his fiance house.
Okay, so he didn't have just one stable residence. He moved between the two?
No, he didn't move between the two. Wherever I stay, my son can always stay with me. He lived with his girlfriend, but he'll come stay at my house home.
Okay. The address that that I have on most of my documents is an address from Chicago, Victoria Lane in Chicago.
Okay.
Who resides at that address?
That is my cousin. That is my cousin Tracy, who he does call mom too. But that's, I'm sorry, that's my cousin.
Okay, so how often did he reside with your cousin?
He lived with my cousin before he moved to Georgia about 5 years ago.
Okay. Is, one second. Is that the address that he normally used on documents or his license?
Yes, because that's me. Like, even though I live in Georgia, even when I lived in Illinois, I always use 1524 Seymour. That's a family house, you know, so even if you're moved, you know, your mail is going to go to that address.
Okay, so so even though he moved to Georgia, you said 5 years ago, he still used your...
No, he didn't use that. I'm saying if he did put that down, that's just probably a comfortable address he remembers.
Oh, but you don't know. Okay.
Yeah, I can't tell you that.
Okay.
I'm just saying.
Okay.
Out of my own era, I've done it too. Familiarity. That's a family home. I always use that address.
Okay. Where was your son, or did your son work before he was arrested?
Did he work before he was arrested? I can't tell you that. I don't have no knowledge of that. He didn't tell me he was working.
Okay.
I can't tell you that.
Okay, I understand. Thank you.
I do know that he was proud to be engaged and he was having a little a baby. That is the furthest that I got.
Okay, I understand. Judge, I believe that's all I have for Ms. Thompson.
Judge, a very brief follow-up.
Go ahead.
Ms. Thompson, you mentioned 5 years he's been in Georgia. The information that I have, if it showed that he was been in Georgia for 6 years. Do you have any reason to doubt he's lived in Georgia for 6 years?
Look, can I tell you something? It might be 6 years. Like I said, I'm 45 years old. I may have made a mistake, but I know that it's been more than 5 years. It's been 5 years or more that he's not been in Illinois.
And am I correct that all of his immediate family live in the state of Georgia, including you and a sister that he has?
Yes, we moved to be with him. Yes, me, his sister, all his siblings live in Georgia.
Okay. All right. No further questions.
Thank you.
I don't have any other questions for Ms. Thompson. I would like to go into Mr. Thompson's history.
Well, I hadn't finished.
Oh, okay.
I was saying that I wanted to put her on because she was going to work.
Oh, go ahead.
Okay.
Well, hold on a minute, because I didn't get a chance to ask the question, but if she has to go to work, there's no problem.
Ms. Thompson, are you still there?
Okay.
Okay.
No problem.
Oh, no, there she is.
Hello? Yes.
Yeah, I think the judge may have questions for you.
You go ahead and finish. Did you have anything else with her?
I don't have any more questions of her. I had more to my presentation.
All right. So let me ask Ms. Thompson, let me ask you this. First thing you said, you make mistakes because you're 45 years old. But then I get a clear waiver for everything. But anyway.
Yes, sir.
So anyway, how old is your son?
She's frozen.
Attorney Mohammed, how old is he?
27.
All right. So I'm gonna let her go to work. I have no questions.
Okay. You can log off, Ms. Thompson. If you can hear us, you can log off.
Thank you. All right, go ahead, Attorney Muhammad.
Okay. So, Judge, he has lived in Illinois as a juvenile, but he's lived in the state of Georgia for 6 years, and as indicated, his entire family now resides in Georgia. He owns his own recording studio. He actually is an audio engineer and is employed through both work that he does at his recording studio and
how old is my son? He's 20. He's like, all right.
Yeah, Ms. Thompson, if you could log off. Okay.
Judge, there is a way for you to, you can exit her out.
Yeah.
Okay.
She's gone. Mm-hmm.
All right. Good.
Okay. Yeah. So at the time of his arrest, he had two businesses that he had going. He's an audio engineer and operates his own recording studio, and he also had recently started a moving company with another individual. And his companies were doing well, both in the state of Georgia. He's lived in Georgia for 6 years. I discussed his criminal history with the state. It's my understanding from talking to my client that his Illinois history, with the exception of 2 offenses, are all juvenile. The state indicated that they saw a number of offenses out of Illinois. So I don't have a copy of the Illinois history, but I would just state that if it's anything beyond a theft charge, which was a shoplifting incident at when he was 22 years old, which would have been 5 years ago when he was visiting in Illinois. And then another incident when he was 19, which was a robbery by snatch. Other than those 2, anything else out of Illinois, is my understanding, would have been when he was a juvenile. I don't have anything to contradict that right now, but like I said, I don't have a copy. In the state of Georgia, he has one 2017 misdemeanor offense, which is an obstruction, and a 2018 felony shoplifting. Those are the extent, that's the extent of his criminal history. There is an open charge in DeKalb County that is unresolved with charges that arise from his presence in a vehicle as a passenger with other individuals. And there was misdemeanor amount of there was marijuana inside of the vehicle, a financial card, and a firearm inside of the vehicle. My client was charged, but I would just state to the court that my client was only a passenger, and it's our belief, our strong belief, that that entire case should resolve without any conviction as it relates to my client. So with that being stated, we have the one felony shoplifting in Georgia, the misdemeanor obstruction, and then the two incidents in Illinois, one when he was 19 years old, as the extent of his history. So, Judge, it's my understanding that all of the charges have a bond except for three. That would be the hit and run, fleeing from a police officer, and serious injury by vehicle. We're asking that the bond that you set for those three charges in the aggregate be no more than $50,000. The remaining charges, if I've added them right, the bond and fees total $14,250. And so whatever you impose for these three that don't have a bond would be in addition to that $14,250. My client's been in custody since January 26 of this year without bond on those charges. It's my understanding from talking to the state that they prefer that my client stay in a no bond status, and that their recommendation, if the court were going to impose a bond, would be at $150,000. $150,000 bond would effectively be a no bond. I'll state to the court that really, in truth, anything over $50,000 would be at a no bond, would place him in a no bond situation. I've spoken to my client. He has indicated that he has been in contact with the victim's mother. We would relate to the court that as of yesterday, they have been in communication, and I don't want to overstep it, but our understanding is that she did not oppose bond, and I'll just leave it at that. Ms. Freeman indicated that she's spoken to some family member, and they didn't indicate that, but I don't know if it was necessarily the victim's mother. I believe those are all of the issues that we wanted to present to the court. I guess the last thing is the shoplifting offense. There is still open probation for that 2018 felony shoplifting. It's my understanding that even upon posting bond, my client would still have to be transported over to Gwinnett County to deal with the probation revocation issue. I've discussed this extensively with my client. There have been discussions with the probation officer over there, and particularly given the fact that it's now been 7 months without indictment, my client is just sitting here in the COVID-19 situation with regard to trials. We believe it's in his best interest, even given the fact that he would be transported over to Gwinnett. We anticipate it'll be in his best interest to go over and to resolve that, and that he would ultimately be able to handle this case after resolving that from the street. We also discussed the possibility of him getting a GPS ankle monitor to alleviate any concerns that the court may have. My client is prepared to do that, and we'd ask the court to consider a GPS ankle monitor and any restrictions with regard to the timing that he could leave the home, or whether he could leave the home at all, if the court would consider that as well. with that, we'll submit to the state.
All right, Attorney Freeman.
Thank you, Your Honor. This is a case where this young lady lost her life. This case, when police were trying to pull the defendant over, instead of stopping, he accelerated, and it turned into this police chase that resulted in this young lady losing her life. And so, as Mr. Muhammad, talked about, Mr. Thompson is on probation out of Gwinnett for felony shoplifting, and he does have an open case in DeKalb. It is still open. I don't have the facts of that case, so I'm not going to represent what happened in that case, but it is for a felony possession with intent of marijuana. I think Ms. Muhammad indicated it was a small amount. Well, he was charged with a possession with intent, financial transaction card theft, as well as possession of a firearm during the commission of a crime. And those are still pending in DeKalb. And I did indicate to Mr. Muhammad that the history out of Illinois, now the information that is on file that was presented to police when Mr. Thompson was taken in was his address in Illinois. And I know his mother has indicated that she thinks that maybe he used that because it was familiar. But whether that's the case, the address that Mr. Thompson has been using is in Chicago. So, and I think based on the mother's testimony, that was her cousin or aunt, I can't recall, but he still has family there. So I certainly will say that there is a chance that he would flee. But looking at his Illinois record, let's see, going through here, and I'm not going to try to figure out if he was a juvenile or not. Just looking at the years, it doesn't state juvenile, and so if it is, I don't know. But looks like from 2004, there was a shoplifting, and what is this? 2004 looks like felony larceny. In 2006, it says there was an assault, and it says a felony. And it looks like it started as an aggravated battery / school employee. And I apologize for it. It takes a minute to go through the way Illinois has their GCIC. There was
Judge, if I could interject, it looks like he turned 17 years old in 2010. So I just want to state that.
All right, thank you. There were some traffic offenses that are on his history. And that says 2012. And what year is this? Again, a battery in 2005. There was a robbery in 2006 where he received probation.
It was a robbery in what year?
Sorry, in 2006, he got probation. There was a battery in 2012. it looks like in 2000, in 2009, a burglary.
Oh, that's juvenile, right?
Everything she mentioned except for the 2012 is all
Okay,
juvenile.
I don't need to hear anymore. Thank you on that one, on the juvenile.
But then there, and so going to 2010, looks like there was larceny, disorderly conduct. In 2012, looks like there was a theft of stolen property and a larceny. In 2016, looks like there was a theft, larceny. It says theft, control, intent. I'm not sure what that means, but it says felony. And then it looks like in 2017, it says escape, failure to return from furlough. And it sounds like that may have been possibly a work release or something, but it says failure to return from furlough. And then it appears that there may have been a violation, and then from 2017, he was sentenced to 2 years imprisonment, and so that's what I have out of Illinois. I think that was the last. Yes, that was the last thing I have out of Illinois. So, so Mr. Thompson certainly has ties to Illinois, and certainly there may be the potential to flee. And Judge, I indicated to Attorney Muhammad, I don't have an indication from the decedents, from anyone in her family, that they are for or Mr. Thompson receiving a bond. That is not information I have, so I cannot represent that to the court. But we heard the testimony from Mr. Thompson's mother when I asked her if he had a job before he was arrested. She couldn't answer. She didn't know. She indicated that he lived between the decedent and her house. So it doesn't sound like there was a stable living arrangement. And so given all of that, Your Honor, and I know he's been in for quite some time, but the state would ask that the charge where he doesn't have a bond, that he remain on no bond status. But in the alternative, given how long he's been in, if the court is inclined, and what I indicated to Mr. Muhammad, what I would be asking is for a minimum of $150,000 total, as well as a GPS. And we would certainly need the address where he's going to reside, given his ties to Illinois and the instability of where he resided before he was arrested.
Judge, brief response.
One question, Attorney Freeman.
Yes, sir.
he's been in 90 days without indictment?
Yes, it appears this, let's see, the warrant was taken out on January 26th. And give me 1 second, I can pull up his confined date.
So what would be your basis for asking for no bond if in fact under law he's entitled?
Well, again, the information I have just based on the family, given his ties to Illinois, and it seems like he had numerous run-ins with the law in Illinois. He's currently on probation here, and so that would be my basis. But I understand it's been after 90 days, and that he is entitled to a bond, and that's certainly why I said in the alternative, I would ask for a minimum of $150,000 with a GPS.
Attorney Muhammad.
Yes, Judge. My first concern is there was a number of juvenile offenses.
Okay, I heard the juvenile offenses, but I think in addition to that, I don't have to dwell on the juvenile.
Okay, and then we heard there may have been this and there may have been that, but may have is a loaded couple of words as far as a couple of things that were mentioned in 2017 with regard to Illinois. And I would just say that just we don't have anything to corroborate those 2017 statements, and there seems to be a lack of clarity on that. What we have are the two incidents, one that I had mentioned.
Okay, we don't have to go back over it.
Okay. So the other correction I wanted to make, he is not charged with intent to distribute in that open DeKalb County case. There's a co-defendant on that case who was a driver, and as I indicated, they charged my client as well, but every indication is he is not going to be convicted. And I just want to state that to the court that is not one of the charges. I have the accusation right here in front of me. And then lastly, my client was engaged. They were set to be married in March. So I think what the state is doing is describing a situation where a couple is going to move in permanently with one another, and that the situation is, he has one living situation. He's also living with his girlfriend. They're going to be married, and that will be his permanent residence, and describing it as instability. It wasn't instability. It's that he was going to be married. He would have been living with his fiance. And so those are the only points I wanted to correct for the record. He's been in custody for 7 months without bond on these charges.
All right, after considering the evidence in the case, the court is not in a position to oppose the state's amount of bond of $150,000 with conditions, if any, if they are feeling appropriate by the state, given the fact that by the very nature of the charges, even which Attorney Muhammad has indicated that they had to perform a pit maneuver to get him to stop after all these other traffic violations in and of itself is enough to cause serious concern for his flight or failure to appear. And that's in addition to the fact that he's on probation. That's in addition to the fact that he has pending charges and has several felony convictions. And the other concerns the court shares, arguments, concerns, and positions by the state regarding actually where he lives and regarding his still using the Chicago address, and regarding his position, his ties to the community. His mother really can say too much about him. The person he was supposed to be married is deceased, unfortunately. And so we don't really know what his living situation will be. You made reference to recording studio and own some businesses. I don't have anything to confirm that at all. So based on everything, the court would deny, the court will not oppose the state's position of $150,000 bond on those charges that had no bond, or whatever was communicated to the Attorney Muhammad by Attorney Freeman. And I find he posed significant risk of flight or failure to appear in committing felonies pending trial. That will conclude this case.
Judge, can I ask one question? Would the court be inclined to make the total bond with all charges 150,000? I think the way the state even referenced the recommendation was a total bond of 150,000.
I'll go with whatever the state agrees to.
That's what I was in a total.
All right, then that's what it'll be.
Yes, Judge.
Okay. All right. Then Ms. Thompson, go back with the deputy. That'll conclude this case. I'll ask state to prepare the order, and we'll get signatures by you, Attorney Mohammed, and we'll get that back so that can be sent over to the jail.
Thank you.
All right, that concludes this hearing. Thank you very much.
And Judge, if I could have about 10 minutes to finish writing this up to send to Mr. Mohammed.
All right, 10 minutes.
All right, thank you.
All right, we got 2 left with Attorney Toles, right?
Yes, sir.
All right.
Judge, I'm back. I'm ready for the next hearing. Chris, which
Okay,
one we
I'm
doing
coming.
first?
I'm sorry.
Which one are we doing first?
Let me talk to the judge about Sturdivant because
Okay.
that was it's gotten so
Wait, we're still on YouTube.
yeah.
Okay. Judge, we're still on YouTube if you can hear us.
Okay. All right, what do we need to do?
Judge, I wanted to be on Sturdivant. I wanted to address a couple of things on his before maybe the court consider some things.
Well, can we do Nolan first then, since we're on YouTube, and then do Sturdivant last if you need to speak with a judge before the hearing?
That's fine. I just was wanting to get it, maybe to release some folks.
It doesn't. Okay, whichever way.
Yeah.
All right. Is someone suggesting I go off of YouTube right now?
Well, if Mr. Tolles needed to discuss something with you, either you can send the three of us to a breakout room or go off of YouTube.
All right. All right. So, ladies and gentlemen, we got what would in effect be in the courtrooms approaching the bench. So I'm going to put the three of us in the breakout room, and we will be back to move forward with these last two cases. So let me see. This is a new one for me. So let's see what we do. But it shouldn't take but a minute. All right. So we got. Attorney Freeman, can you hear me?
Yes, Judge.
Okay, I have the box open for you and Attorney Tolles, but what about, doesn't say anything about how I get in.
You have to assign yourself to the same breakout room.
I don't see mine.
And I don't have anything that came up assigning me to a breakout room, but it's the same way you would do everyone. You have to assign yourself.
Okay, I don't think. Oh, all right. I don't see how I can assign myself because I don't see where it has something for me.
Okay.
On the option.
We can just go off of YouTube if it's and then that way whatever Mr. Tolles wants to bring up won't be on YouTube.
Let me.
So I now have a breakout room invitation.
Okay, let's see. Still don't see what I can do. All right, well, let's do this.
And I have an invitation too as well, Judge.
Right. I'm going to send you guys to the breakout room and see if I can get in, figure out a way to get in. If not, then I'll bring you back and then we'll go off YouTube. All right. What happened? Y'all left and came right back?
It didn't let us go.
Okay.
Mm-hmm.
Okay. All right. Didn't do it. So anyway, I think what I'm gonna just do is go off YouTube right quick.
Okay.
All right, ladies and gentlemen, I'm going off YouTube and we'll be right back.